petition at 2 o'clock.
What is the matter?
Lordship.
What matter?
Urgency, Lordship. What happened, Lordship?
Oh, what is the matter? RSA, CRP?
CRP.
Okay.
What? Much.
I have a similar player, CRPIO. Attachment order has been issued. The Office of the Deputy Commissioner is at risk. I have some urgency.
Okay.
Hello.
May I please allow? I beg to mention.
Yes, Mr. Jain.
Yes. Lordship, I beg to mention some items. They have not come for a long time. They may come after vacation on 15th or 17th. After vacation.
Okay. You give the mention memo here.
Similar prayer, my lord, I have. After vacation, my lord, listing.
What is the matter? Hearing matter.
One is CRPIO, my lord, and one is RSA, my lord. RSA hearing, my lord.
Hearing before registry, pray before registry. CRPIO on 17.
May I please, your lordship? Lordship. May I please, urgent matter, lordship. Lordship may kindly allow to list at 2, lordship.
Okay.
Yes, Mr. Lordship. Your Lordship, I beg to mention item number 4, 5, and 6, Your Lordship. Your Lordship, senior counsel is not keeping well, Your Lordship.
Item number 4, 5, and 6. Heard, miss. What is your name? What is your name?
B. Ronghangpi.
B. Rohangpi.
Happy.
Rohangpi, learned counsel, appearing on behalf of Mr. A.K. Purkasta, prays for an adjournment on the ground that conducting counsel for the petitioner is not well. The prayer is allowed. Considering the ground, the prayer is allowed. Let this matter be listed. 22nd July.
Your Lordship, I beg to mention item 23. Service is yet to be completed.
What is your prayer? What is your prayer?
Your Lordship, service is yet to be completed.
Wait for your turn. We'll pass orders when the matter is called.
May I please, your lordship? Lordship, I have to mention item number 15 of the daily list. Lordship, the matter with the consent of other side, lordship, the matter may be passed over for the day.
Heard, Mr. What is your name?
P. Bhattacharya on behalf of B. Purkasta.
Heard, Mr. P. Bhattacharya, appearing on behalf of Mr. B. Purkasta, who prays for an adjournment. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed. 27 July.
Fixed date may not be given, lordship.
Let this matter be listed after 4 weeks on a date to be fixed by registry. You are for appellant, okay. 4 weeks after on the date to be fixed by registry.
Deeply obliged.
Your lordship. Your lordship, I would like to mention an interlocutory application for listing in production list, your lordship. The matter was, your lordship, by order, it was allowed today itself, your lordship, but in the supplementary list, it has not been.
What is the urgency?
Urgency is, your lordship, there is a small mistake, sir, your lordship, regarding the description of name of the claimants, your lordship, in the MEC appeal case.
Okay.
It will take some limited time of hearing.
Add two.
Deeply obliged, your lordship.
May I please, Your Lordship?
Add two in the second half, not add two in the second half.
At 2, your lordship.
At two, we have other matters.
Lordship, sure.
May I please, Your Lordship? Lordship, I'm praying for listing of one CRP matter for orders, Lordship, after vacation.
27 July.
Yes, Lordship.
Motion. Admission under on hearing on 4111. Motion of pisot hearing on 4111. Lam pisot orders 4111 hearing to agote ho. Nole ma'am kata notice. Yes.
Yes, very please. My lord, this petitioner is, my lord, has filed a revision against the, my lord, judgment, my lord. Page 25, my lord. passed by, my lord, this Mahasa Autonomous Council Court, my lord. Basically, the customary law and the uses are involved, my lord. So at this stage, my lord, I am only praying for notice only, my lord. Since the NC Hills Standing Council is also appearing, my lord. Only record may be called for, my lord.
What order you are impugning?
Impugning page 25, my lord, judgment and order passed by Autonomous Council Court,
What is the forum where appeal lies?
my lord.
What is the next forum against
Next
that?
forum is High Court, my lord. Under revision. my lord.
Revision only?
Yes, sir.
No appellate forum is
No
there?
appellate. Already appellate forum is this, my lord, Limasa Autonomous Council Court. That is the my lord, highest court, my lord. After this, my lord, we come under High Court, my lord.
And Mr. N. Barua, learned, sorry, B. Barua, learned counsel for the petitioner. Also administer, what is your name?
D1000 lordship.
D1000, learned standing counsel, Dima Hasao Autonomous Council. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the judgment dated 26/6/2024 passed by the Mahasa Autonomous Council Court in LD case number 207/2023. Issue notice to the respondent. Since Mr. Thousand is appearing for respondent number 2, no formal notice need to be issued. You have received the copies?
Lordship.
Copies of petition? Have-
Yes, cross. Yeah, please.
However, as regards respondent number 1 is concerned, the petitioner shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 14th of August. List accordingly.
But that record may be called for.
Let the records of LD case number 207/2023 as well as what is the record of customary court?
My lord. Limasa Autonomous Council.
No, this order has impugned order, judgment has been passed in appellate capacity.
Appellate.
What is the original record?
Originally, my council has taken up, it was referred to this court. Originally, my Autonomous Council Revenue Authority, they take up the matter, then they refer. So this is the,
Let the record of LD case number 207/23 be called for from the Mahasa Autonomous Council Court. The registry to take steps for requisitioning the records, list accordingly.
Lordship, may I make a small submission? So, Lordship, that's impugned judgment and order is of 26/6/2024, and it has been filed after beyond limitation also.
227.
227.
227.
More than a
The-
year.
The respondent may take the plea of, may take up the question of maintainability of this revision petition. Limitation, how limitation in 227 matters?
Lordship, as per the High Court rules, Lordship, limitation is of 90 days
For
for referring an application or appeal before the Honorable High Court. Lordship.
under 227.
Lordship, as per the Appendix 2 of the Assam High Court jurisdiction over District Council Courts Order
Okay,
1994.
The question of limitation, question of maintainability on the ground of limitation is kept open. Say may be pressed by the respondent side on the next date of hearing. We'll keeping this question open.
Yes, obliged.
Obliged.
May I please, your lordship?
Yes,
This is a reversal judgment, your lordship. The respondent has filed a suit for eviction and recovery of area of rent. The suit was dismissed. Thereafter, the respondent preferred appeal, and the appellate court reversed the judgment of trial court, your lordship. And now, your lordship,
what is the
Uh,
date of judgment?
lordship, appellate court judgment starts from, your lordship,
Heard Mr. A. R. Shom, learned counsel for the petitioner. This revision petition has been filed by the petitioner under section 115 of the Code of Civil Procedures, impugning the judgment and decree dated 25/5/2026, passed by the Court of Learned Civil Judge Senior Division Udalguri, whereby the judgmental decree dated 12/8/2025, passed by the Court of Learned Civil Judge Junior Division Udalguri, title suit number 9/2017, was set aside and reversed, and the appeal preferred by the present respondent was allowed. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 14th of August. Let the records of the trial court as well as that of revisional court, that of appellate court be called for. The registry shall take steps for requisitioning the records. Stop. Any execution case has been filed.
lordship, the suspension of the appellate court order may be stayed. The operation of the appellate court may be stayed.
Considering the submissions made by learned counsel for the petitioner, as well as after going through the averments made in the revision petition, the execution of the impugned judgment passed by the first appellate court shall remain stayed till next returnable date, list accordingly.
Oblige, your lord.
The next case especially for non-performance of duty of the learned member tribunal, support matter 3. Last 7 months, he did not deliver of judgment being pending MSCT case since 2018 also. And this case has been remained for judgment stage. Accordingly, Honorable Court has asked a report from the member tribunal laws. The why that case has been pending in judgment stage last 7 months. That is the order of this coordinate bench Honorable Court. Order dated 12/6/2026. The initially hearing was conducted 25/7/2025, and thereafter again hearing was conducted, that is 10/11/2025. That is the argument has concluded, that is on 10/11/2025. Accordingly, tribunal fixed this matter for judgment, that is 29/12/2025 again. But since then, matter has been delayed and passed order one after another. In case remain for judgment. If your lordship, that report has not submitted by the learned member, tribunal not.
Report has been submitted. I'm
Yes.
going through it. Fixed on 7 July. Heard Mr. M. Soike, learned counsel for the petitioner. In pursuant to the directions of this court, the report from learned member MSCT number 3, Kamrup Metro, Gauhati has been received. Has been received. I have gone through the report. The learned member MSCT number 3, Kamrup Metro, Gauhati has stated the reasons for delay in delivery of the judgment and has further stated that the MSC case that the judgment in MSC case number 2538/2018 has been now fixed for delivery on 7/7/2026. Accordingly, let this matter be listed. Reopening on 14th of July 2017. However, registry shall forward the order passed by this court on 12/6/2026 along with this order and the report of the member MSCT, report of the learned member MSCT number 3, Kamrup Metro, dated 22nd June 2026 to forward a copy of the orders passed on so and so along with a report of the learned member MSCT number 3, Kamrup Metro and Gauhati, dated 22/6/2026 to the Registrar of Vigilance of this court for taking up the matter on administrative side. Let this matter be listed again on 14th of July.
No.
Item 7.
After some time, seniors and late code number 6.
Item 8.
May I plead your lordship? My lord, the petitioner filed a land grabbing case, my lord, wherein, my lord, inadvertently the schedule of the land was not annexed, my lord, inadvertently. Therefore, he filed an application praying for amending the petition by inserting the schedule of the land, my lord. That petition, your lordship, and that page, my lord, 53, my lord, annexure 8. Only the schedule of the disputed land, my lord. 53, my lord.
Where is the impugn order?
And impugn order at page 59, my lord, annexure 9. And operative portion, your lordship will find at paragraph 2, my lord. Page 59. So that petition has been rejected, my lord. At this stage, I pray that, my lord, a notice may be issued, my lord.
Okay. Heard Mr. D.P. Bora, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 26/3/2026 passed in special land grabbing case number 5/2022 by the Court of London, Additional District and Sessions Judge Mujahid, Shankar Dev Nagar, whereby an application filed by the present petitioner under Order 6, Rule 17 of the Code of Civil Procedure 1908, seeking amendment of the petition filed by the present petitioner before the said court said was rejected. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by user mode within 7 days from the date of this order. Returnable on 14th of August. 14th August.
Obliged, my
Item
lord.
9.
Lordship, I am the defendant in title suit number 11 of 2025, pending in the Court of Civil Judge Jorhat. Lordship, I have filed restatement after received the notice from the Honorable Court. And thereafter, before issue has been framed, I have filed a counterclaim. Lordship will find at counterclaim at page 40 with a petition to allowing the petitioner to file the accept the counterclaim, page 37.
Yes.
Lordship, got it. Defendant filed counterclaim against the plaintiff. Defendant could not file the counterclaim along with the WS, which was filed on last day. Due to non-availability of some important documents, defendant could not file the counterclaim along with the WS. So, prayer is made to allow the defendant to file the said counterclaim today. This prayer is made bona fide in the edge of justice. This application has been filed along with the counterclaim. Counterclaim will also find at page 40.
Where is the impugn order?
Also will find page 55. It has been rejected considering the judgment without relying the full bench judgment, which has been Lordship, they have relied on the judgment of the Honorable Supreme Court. Lordship will find at page 56. May I take your Lordship, page 56?
Yes.
Division Bench Honorable Supreme Court Ramesh Chandra Alia and Iman observed that 3 judges' decision of Arjun Singh Iman rightly make a counterclaim in his territory, and counterclaim is not admissible in a case which admittedly not within his territory provision. Thereafter, court has said that the leave is a discretion. Lordship will find page 57. May I read, Lordship, page 57, third paragraph. The
Yes.
present issue is not regarding the stage of filing of or delay in filing. Present issue is regarding how it is filed. Counterclaim here is not filed in any of the way described by the Supreme Court in a case of Ramesh Chandra and Anil Pariwala.
What were the ways?
Lordship, Supreme Court has clarified, full bench of the Supreme Court has clarified, relying the Arjun Singh case. Lordship will kindly see the Supreme Court full bench judgment that is reported in 2022 to SCC 394. Here, Lordship will find page 12. Page 12 of the judgment.
No, how you have not followed the.
They said that what has been stated, Lordship will find. Last portion.
Three modes are in the written statement by
Before
amending
issue-
the.
Before issue has been framed and case has proceeded, counterclaim is filed. That is the Honorable Supreme Court decision.
No,
and
no.
leaves with me.
Why your prayer was rejected?
Lordship will find page 58.
50?
58. Hence, following the principle laid down by Honorable Supreme Court in the division bench decision, Ramesh Chandra Alia and three judges bench decision, Arjun Singh and Manohar Kumar, counterclaim filed by the defendant, performer defendant number 2 is rejected, as same is admittedly not within this statutory provision.
No, what provision was not followed?
They said, Lordship, the leave application has not been filed. Leave application has been rejected. Lordship will find page 56. Page 56 again. Secondly, last but one. Secondly, a counterclaim may be preferred by way of amendment or incorporate subject to leave of the court is within statement already filed. Leave application has been already filed. And before issue has been framed. And Honorable Supreme Court, this
Order, the impugn order does not indicate what was the lapse on your part. It says three modes are provided in the written statement by amending the written
within
statement
time.
or by a subsequent pleading. You file
By subsequent pleading.
subsequent pleading by taking leave, seeking
Taking
leave.
And full bench Supreme Court has said this judgment, which has been relied by the Honorable Court, that has been decided in the full bench judgment. And full bench has, the Honorable Court has kept two judges bench. And thereafter, this judgment has been relied on by the full bench.
Now at what stage suit is pending?
Issue?
Issues are framed.
No.
Okay, we'll issue notice.
Lordship will find the order sheet I have annexed, Lordship.
We'll issue notice. Heard Mr. S.K. Goswami, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, Dr. Bonumala Bezburwa, impugning the order dated 26/3/2026, passed by the Court of London Civil Justice Senior Division, Jorhat, entitled suit number 11/2025, by which the prayer for admitting the counterclaim filed by the present petitioner was rejected by the trial court. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 14th of August.
Further proceedings should be stayed, otherwise Lordship it will proceed, Lordship.
Considering the submissions made by learned counsel for the petitioner as well as the averments made in the instant revision petition, further proceeding of title suit number 11/2025 shall remain stayed till the next returnable date.
In fact, I'll submit, Lordship, the objection has not been filed. The plaintiff has not filed the objection to the plea
No,
petition.
order is not clear as to what was the lapse on your part.
Let's leave. Leave application has been filed.
But leave has been filed. Leave
Lordship,
application has been filed. You have filed a leave application.
application before issue has been framed and on next date of the filing of the
No,
appeal.
that is what I am saying. The order does not indicate the lapse. But we are issuing notice.
Of license.
Item number 10.
Motion. Debaters are there.
Of the Indian Bank. You have not received the copy there.
But not, today the
CRPI.
petitioner is not there. We'll fix it after vacation.
Yes, sir.
None has appeared for the petitioner on call. Mr.
And Sharma
M. Sharma, Learned Counsel
for Indian Bank.
for Indian Bank. That is respondent number. The sole respondent is present. Let this matter be listed again. 17th of July. Volume to. Yes, Mr. Bhattacharya. No, you are not audible.
Am I clear now?
No. Yes.
Now,
Yes.
may I proceed back?
Yes.
Here, what is dependent lordship? You can find a petition under order 7.
No, Mr. Bhattacharya, you are not audible. We'll call computer section people and we'll take this matter after some time. Computer man.
12.
Yes, please, your lordship. Yeah, my lord, interim order is in page number 23, my lord. Relevant portion is on page number 27, my lord.
What is the
Is that therefore the opposition directed to pay maintenance standard light at the rate 10,000 per month to the petitioner from the date of filing the petition?
your husband?
My lord, here, my lord, petitioner, the respondent wife is also a TET teacher, my lord. And she is earning near about 40,000 and husband is earning 50,000, my lord. But my lord,
Where is the impugn order?
interim order is in page number 23, my lord.
Interim maintenance.
Interim maintenance, my lord.
How much you were directed to pay?
10,000 per month, my lord.
Will issue notice.
Yes, my lord. My lord, kindly, my lord, there is the page number 29, my lord.
Yes, what is this?
26, my lord, the honorable court hide page number 30. In page number 30, last paragraph, my lord. In the light of aforesaid discussion and finding, let the report be called from the DPO of the opposite party, namely Sitan Bosan, that is Commandant 84 Battalion Headquarters CRPF, so and so, as to whether he is drawing and disbursing the office opposite party. If yes, then how much salary the opposite party is drawing at present, and send a copy to the DPO. But that order may be stayed, my lord.
Why?
Because, my lord, they are going to
This is only a inquiry by the
inquiry, my lord, my lord. But the application is from page number 29, my lord.
No stay now.
Notice is on that.
We are issuing notice. Heard Ms. A. Gayan, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Chittaranjan Basumatari, impugning the order dated 23/4/2024, passed in Ms. J case number 20/2022 in connection with title suit within bracket M number 64/2022 by the Court of London District Justice H4. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of August.
I just petition, I have challenged the order dated 35 malad, kindly see page 58 malad. Malad in money execution case malad, I had paid malad installment wise some monies malad, and according to 1,38,000 already paid malad. And thereafter malad on 30/5/2026 malad.
Where is the impugned order?
Malad page 58 malad, annex 13.
Yes. What is this?
Malad, it is the decree holder side is represented, judgment debtor by petition number so and so, deposited amount rupees 15,000 only and paid made to accept the same. Let the deposit amount so and so. Paragraph 4 malad, on perusal of the case route, it reveals that the judgment debtor side has already paid rupees 1,38,000, including today. The decretal amount
You are judgment debtor
my lord.
or decree holder?
My lord, the judgment debtor, my lord.
Okay.
And my husband, my lord, borrowed the amount, my lord. And subsequently he committed suicide, my lord. And subsequently, my lord, that writ issued, my lord, and it is failed, my lord. Subsequently, I willingly appeared before the court, my lord, and pressed, my lord, some time for payment, my lord. Accordingly, I paid the money, my lord, installment wise, my lord.
Now, how much is outstanding?
And
No, attachment order has not yet been passed.
my lord. But my lord, I have more no landed property, my lord, for attachment, my lord. I have no report as no report as seen, my lord. But I admitted, my lord, my husband, my lord, borrowed the amount, my lord. But he committed suicide, my lord.
Now, what is the error in the order?
My lord, I have no able to my lord, pay the entire amount within one month, my lord.
No, that is okay, but how the impugned order is defective? Where is the wrong in
My
the?
lord, it is, my lord, hence, my lord, I appeared, my lord. It is, my lord, the Nozi report also stated that, my lord, no property is.
Now, what do you want?
My lord,
You don't want to pay back the money?
Paid the money installment wise, my lord.
Now, pray before the executing court.
My lord, in pursuance of the order of this honorable court, my lord, reflected, my lord, order number 18, dated 26 March 2025. The execution case has to be, my lord, executed within a period of 6 months. In pursuance of that order, my lord, impugned order has been passed, my lord. Therefore, I praise before this honorable court, my lord. It is,
No,
it is a, my lord, exceptional case, my lord.
what is your prayer?
Prayer, my lord, I, my lord, paid the money, my lord, installment wise, my lord. Rupees 15,000, my lord, per month, my lord. Otherwise, my lord, I have no ability to pay the entire amount, my lord. I am the PPL family, my lord.
Heard Mr. K.R. Padgiri, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 30/5/2026 passed by the Court of Learned Civil Judge, Senior Division, Lakhimpur, North Lakhimpur, in money execution case number 4/2023, arising out of money suit number 6/2020-2019. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days, returnable on 4th of August. Till next returnable date, the operation of direction given by the given by the executing court in paragraph number 5 of the impugned order shall remain stayed. However, it is hereby made clear that the installment which was earlier directed by the executing court, the payment of money in installment which was earlier directed by the executing court shall continue to be paid by the present petitioner during pendency of this revision petition list accordingly.
Obliged.
May I please, Your Lordship? Lordship, now,
Receipt
am I-
equivalent. Sound. Yes, Mr. Bhattacharya.
am I audible now, Lordship?
Yes.
Lordship, let us depend here. We as a dependent, Lordship, we filed a petition under order 7 due diligence. Actually, filed a petition under order 7 due diligence. In election 6 page 69.
No, you are not audible. You are not clear.
Sorry, Lordship.
We'll take up this matter at 2.
Lordship.
At 2 p.m. Dutaragar Sabha.
May I please, Lordship, I have attempt number 10. I was on late, Lordship. Kindly take up the matter.
You inform the other council, Indian Banks Council. Somebody appeared for Indian Bank. M. Sharma, you inform the council, Mr. M. Sharma, and come together with him.
Obliged.
Yes.
Here, the petitioner initially filed a title suit against the respondents for seeking a declaration of right title and interest and for recovery of possession. And the defendant entered their appearance and filed a written statement along with counterclaim. Then the petitioner came to know that there was 3 numbers of registered sale deed, which was executed by the predecessor of the allegedly executed by the predecessor of the petitioner in favor of the predecessor of the defendants. So, thereafter petitioner filed an application for amendment of the plaint so that they can pray for rejection of the plaint. So, that was allowed. So, thereafter he filed amended petition, amended plaint
You are defendant.
Plaintiff, my lord.
Okay.
So, my lord, amendment petition was allowed. So thereafter, he filed amended plaint. Then, my lord, both the parties again filed their revised written statement. And, my lord, as the, my lord, registered sale deeds were not in the possession of the petitioner, they have filed an application under Order 11, Rule 14. Lordship will find that page 32. In that application, seeking a direction to the defendants to produce the copy of the registered sale deeds in the before the court. But, my lord,
Where is the impugned order?
in impugned order, Lordship, that is at page 46. That order passed against the petition filed under Order 16, Rule 7. Earlier, my lord,
Order 16, Rule 7 or Order 6, Rule 17?
Order 16, my lord. That was, my lord, seeking a direction to the
Wait. Where is the
application.
where is the impugned order? Page?
Impugned order is at page 46, my lord. Seeking a direction to the concerned sub-register to produce the, my lord.
No, page 46 is.
Yes, it starts from page 47.
No, your pagination is wrong. Page 47 is, we are in the middle of some judgment.
Order dated, my lord, 22/5/26, my lord.
No. Check the pagination. Check from the record. And we'll take it up after some time. Saboti. 38. Yes.
Was seeking transfer of a matrimonial suit, my lord, from Gauhati to Tinsukia. The length, my lord, will find at page 11, my lord.
On what ground?
There are other similar suits pending at Tinsukia, my lord.
Between the same parties.
Same parties, my lord.
Mr. P. K. Munir, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Jyoti Sharma, praying for transfer of title suit matrimonial number 2/2026 pending before the Court of London District Judge Jorhat to the Court of London District Judge Tinsukia. Learned counsel for the petitioner submits that there are other cases pending between the same parties in Tinsukia. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 4th of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as well as averments made in the instant transfer application, further proceeding of title suit matrimonial number 2/2026 pending before the Court of London District Judge Jorhat shall remain stayed till next returnable date.
But I am paying for transfer of the matrimonial dispute, my lord. Report from Dibrugarh to Tribhumi, Karimganj.
Your wife,
I am the wife, my lord.
you stay at Shribhumi. What is the ground?
Ground is, my lord, page 4. That I have no other source.
Heard Mr. S.K. Ghosh, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Jimli De alias Priya De, praying for transfer of Which case?
Title suit divorce 48 of
Where is the indication?
page 4, my lord.
Praying for transfer of title suit. Where is the indication of the number?
Number page 7, friends. I have annexed.
Why have you not mentioned in the cause title? Transfer of title suit divorce number 48/2025 pending before the Court of Learned District Judge Dibrugarh to the Court of District Judge. Sribhumi Family Court is there. To the Court of Competent Jurisdiction at Sribhumi. Issue notice to the respondent. What stage it is pending?
Next date is 7/7 for filing written statement and service report. SR and WS.
Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August. In the meanwhile, considering the submissions made by learned counsel for the petitioner as well as the averments made in the instant transfer petition, further proceeding of title suit divorce number 48/2025 pending before the Court of Learned District Judge Dibrugarh shall remain stayed till next returnable date.
So kind of pass over there for timing.
After some time.
Item 41.
Right, please, my lord. Hold on, preferring this present petition on being aggrieved by an order dated 3/6/2026 passed by the learned Civil Judge Junior Division number 2, Dibrugarh, my lord. The impugned order, my lord, will find it page number 52. My lord, my right to cross-examination has been closed, my lord. I have already substantially cross-examined. I am the defendant in the original suit, my lord.
Where is the impugned order?
My lord, page number 52.
Why it was closed?
My lord.
What was the lapse which you committed?
Initially, what has happened is that I have cross-examined the PW1. My lord will find the cross-examination at page number 36.
You cross-examined thereafter?
Thereafter, my lord, the case was transferred. Initially, it was pending before Civil Judge Junior Division number 3. So it was thereafter transferred to another court. I have already, my lord, page number 46 is the order of transfer, my lord. So it was transferred thereafter from Junior Division 3 to Junior Division 2, my lord. And there was some miscommunication, confusion, my lord, for which I could not come, my lord, I go on that particular date when the cross-examination was fixed for, which has resulted in filing of a petition on my part, my lord, and ultimately this order was passed, my lord.
No, you have not deposited the cost.
That is one of the reasons, my lord. That is one of the reasons I would admit, my lord. But my lord, the order, if my lord peruses, then there is also a statement that I have not cross-examined. But I have already cross-examined the PW on one particular date, my lord. It is not that I have been taking dates and I am not at all cross-examined.
No, but you further cross-examination was allowed,
My lord.
subject to payment of cost.
My lord, my lord.
You have not deposited the cost.
I could not cross-examine, my lord, on that day. I did not even deposited the cost, my lord. I'll have to admit.
Then why your pair should be allowed?
My lord, only as a last, it's also as the mercy petition, my lord, that I'm praying for, my lord. Only one date is required, my lord, and substantial process already been completed.
You deposit enhanced costs.
My lord, I'll do that, my lord. I'll do that. Otherwise, for my lord, conduct, the party would suffer. That is the only difficulty.
Heard, Mr.
Our sense, my lord.
Our sense for learned counsel for the petitioner. This revision petition has been filed by the petitioner, who is the main defendant in title suit number 10/2023, which is pending before the Court of Learned Civil Judge Junior Division number 2. Which is the district?
Dibrugarh, my lord.
Dibrugarh. Impugning the order dated 3/6/2026 passed by the said court in the aforesaid case, whereby the prayer for cross-examination of how many PWs are there?
Only one, my lord.
Plaintiff's witness by the present petitioner was rejected, and the next date is fixed on 14/7/2026 for the evidence of defendant's witness. Mr. R. Sensor, learned counsel for R. You are on.
Lord.
R. Sensor, learned counsel for the petitioner, submits that though the petitioner had earlier cross-examined the plaintiff's witness, however, he was allowed to further cross-examine by depositing a cost of rupees 1,000. However, as the title suit number 10/2023 was earlier pending before which court?
My lord, Civil Judge Junior Division number 3, my lord.
Civil Judge Junior Division number 3, Dibrugarh, and was transferred to the Court of Learned Civil Judge Junior Division number 2, Dibrugarh. There was some miscommunication, and as such, the plaintiff's witnesses could not be cross-examined on the said date. He also admits, the learned counsel for the petitioner also admits that there has been lapse on the part of the petitioner in not depositing the cost as was directed by the trial court. He, however, submits that unless the petitioner is allowed to cross-examine the plaintiff's witness, he would be prejudiced. He would be greatly prejudiced, and therefore he submits that the petitioner, who is the defendant in the aforesaid suit, may be allowed to cross-examine the plaintiff's witness for the ends of justice. Stop. Considering the facts and circumstances of this case, this court intends to dispose of this matter at the motion stage itself without issuing notice to the respondent. The facts narrated by the learned counsel for the petitioner and as well as revealed from the documents which are annexed along with the revision petition indicates that there was some lapse on the part of the present petitioner in not cross-examining the plaintiff's witnesses on the date fixed by the trial court. However, this court is of considered opinion that said lapse may be condoned for the ends of justice by imposing appropriate cost. Accordingly, the instant revision petition is allowed, and the impugn order is set aside to the extent that it has closed the plaintiffs, it has denied the present petitioner the chance of further cross-examining the plaintiff's witnesses. The petitioner is allowed to cross-examine the plaintiff witnesses, further cross-examine the plaintiff witnesses on a date to be fixed by the trial court, subject to payment of cost of rupees 5,000, in addition to the cost which was earlier imposed by the trial court. The said cost shall be paid to the plaintiff by the present petitioner. Stop. The payment of cost shall be the condition precedent for allowing the present petitioner to cross-examine the plaintiff witnesses. With above observation, this revision petition is disposed of.
Deeply obliged, ma'am.
Sorry. But if there is a petition challenging a judgment passed in section 47 application, what has happened, Lord? We had the respondent had filed an initial title suit for Lordship. We have entered an agreement. In that agreement for sale of a land. Now, in that agreement, there was a clause that who would apply for the sale permission. Lordship,
You are the owner of the land.
yes, Lordship, my father was.
Okay.
My father was, I am the legal here. Now, at page 27, Lordship would kindly see
No,
page
you
29.
You tell me the facts first.
Thereafter, we executed the agreement. That one clause was there, who would apply for the sale permission. There was a dispute arising, therefore, then the respondent filed a title suit. In the title suit,
For specific performance of contract.
performance only regarding that who would obtain the sale permission. Then the learned court decided against me that my father would apply for the sale permission. Lordship would see at page 29, one of the issues, issue number 4,
Yes.
whether in terms of the registered deed of agreement dated 14/10/2014, the defendant is required to obtain sale permission and no objection certificate from the office of the Deputy Commissioner and GMD authority as claimed by the plaintiff. At last, Lordship, it is the case of the fourth paragraph. It is a case of the defendant defendant that the plaintiff failed to procure the no objection certificate. The defendant number 2 in his evidence deposed that the defendant asked him to help him in obtaining sale permission. I considered the specific clause number 2 of the deed of the agreement dated 14/10/2014 and as per the deed, the duty to procure sale permission and no objection was upon the defendant. Moreover, the evidence of defendant number 2 that defendant asked him to help him in obtaining sale permission clarifies that the defendant was under an obligation to obtain sale permission and no objection certificate from the concerned authorities. I have also considered evidence of PW1 that her husband, that is plaintiff number 2, was entrusted to obtain sale permission from the authority and found that the evidence of plaintiff number 2 clarifies that as the defendant failed to procure the sale permission, he voluntarily took the responsibility to procure sale permission, no objection certificate, etc. In presence of clause number 2, the deed of agreement dated 14/10/2014, it is clear that the defendant was entrusted to procure sale permission, no objection certificate, and mere taking the responsibility by plaintiff number 2 after failure of the defendant will not establish that he was under no obligation to procure sale permission, no objection certificate. Accordingly, it was issued. Therefore, in 2017, it went against me. Therefore, we filed in regular first appeal. The regular first appeal also went against me. Thereafter, we filed a review application. The review application was against me on the ground that this ground is not a suitable ground for review. Then we moved to Honorable Supreme Court. In the Supreme Court, it was rejected summarily. However, this was in March 2026. However, in 24/12/2025, Lordship, at page 52, my father died. Therefore, I was trying to make a point that in the stage of obtaining sale permission, my father died. My father was the owner and recorded pattadar, and it was just initiation of the agreement for sale. There was not a concluded sale deed, so there was no crystallized right in his favor also. And in the meantime, my father died. Just before we went to the Supreme Court, my father died. Therefore, we come to the title execution. In the title execution, I made an application that because of the death of my father, the contract was in the initial stage. Therefore, there was no conclusion to it. Therefore, we are not authorized and competent to obtain any sale permission, so the decree has become impossible to execute. Lordship would see now the judgment which I challenge. Lordship would find that at page 866.
No, but you are the heir.
Yes, Lordship.
What the trial court directed by the decree to execute a sale deed and to deliver the possession.
No, to obtain sale permission.
Only to obtain sale permission.
Sale permission.
Oh.
Page 38, Lordship. Decree, Lordship, at page 39. Operative part at page 39, Lordship would say. It is ordered and decreed that the suit of the plaintiff is decreed on contest against the defendant. It is decreed that plaintiff is entitled for specific performance of contract by the defendant concerning deed agreement dated so and so. So it concerned only the deed of agreement dated 1410. That is the agreement for sale. And the issue.
You were not directed to execute the sale deed.
No, Lordship.
Within a.
Because permission was not obtained by then. Suppose we had obtained the permission.
What the executing court will do now?
Yes, Lordship. Now what has happened? Page 66 is my impugn order. Lordship would see we have filed petition under section 47. Lordship, with a specific plea that I have no authority to obtain sale permission. I am my father was the recorded pattadar.
No, what execution the decree holder is seeking before the executing court? What is to be executed?
Is the decree, Lordship.
What is the decree?
The decree is that on issue number 4 that my father has to obtain the sale permission.
But that has not been specifically stated in the decree.
Yes, Lordship, but that Lordship, the issues will determine that, Lordship. At page 29, whether in terms of the registered deed of agreement dated so and so, the defendant is required to obtain sale permission and no objection from the office of the deputy commissioner. That is the specific issue, Lordship. The question and issue number 5 is whether the plaintiff is ready and willing to perform her part of the contract and whether defendant is willing to perform her contract. Lordship, the dispute was regarding who would obtain the sale permission.
Where is the decree?
At page 38, Lodge.
Decree does not specify what you have to do, what decree holder has to do.
Yes, Lordship, that is one thing, Lordship. Otherwise, Lordship,
Heard
what see the
Mr. B-
issues?
heard Mr. B.P. Bora, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners who are the judgment debtors in title suit number 26/15
15.
within bracket title execution case number 48/2017, impugning the order dated 4/5/2026 passed by the Court of London Civil Judge Senior Division number 1 Kamrup Metro in Misja case number 400/2026 arising out of title suit number arising out of title execution case number 48/2017, whereby the application filed by the present petitioners under Section 47 of the Code of Civil Procedure, raising questions about the executability of the decree, was rejected by the executing court. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August. Stop. Considering the amendments made in the instant revision petition as well as the submissions made by learned counsel for the petitioner, further proceeding of title execution case number 48/2017 shall remain stayed till next returnable date.
Deeply.
May it please your lordship. This petition has been filed by the defendant, the main defendant number 123, lordship, against the suit filed by the present respondent number 124, lordship. And respondent number 5 and 9 are government, lordship, and respondent number 6 to 8 pro forma, I have made them pro forma. 6, 7, 8 are forest department, lordship. I have made them pro forma respondent as because the stand taken by the government and forest department is favoring the case of the defendant number 123. The suit was regarding the land which was allotted by forest department in favor of the predecessors, lordship. And they said, lordship, the predecessor has 2 sons and one part is, lordship, the plaintiffs and one part is defendant number 123, lordship. And the suit length which is disputed in this tract.
Defendant number 1 to 3 are your brothers.
1 to 3 are brothers, lordship.
Your brother.
No, lordship, they are from Binod Chandra Das. Sajal Das is the son of Binod Das, lordship. And Binod Das and Hirot Chandra Das are brothers.
Cousin
They are
brothers.
cousin brothers.
Okay.
This is the land which fell in our share, lordship, that was allotted to us by the forest department, and revenue records were also corrected in our name, lordship. But the plaintiff is saying that this plot of land is under their possession and they are cultivating. So along with the plaintiff, they have filed one injunction petition, to which the government also filed written objection and we also filed written objection, lordship. Before going to the injunction point, lordship, may I take your lordship to page number 33?
What are you impugning now?
I am impugning the order passed by the First Appellate Court, lordship, by which the stay of the injunction order was not granted. Lordship, the stay injunction order passed by the learned trial court allowed, moreover, lordship, directed the plaintiffs to possess the suit land and cultivate without any interference by the defendants, lordship. In fact, it is our case that we are in possession of the suit land. So learned trial court, lordship, while directing interim temporary injunction,
Your
finally
appeal was dismissed.
no, lordship, appeal was admitted, but my
But
interim prayer was
interim prayer
rejected. So in respect to the rejection part,
you are against the interim.
against that order. And I am praying before your lordship and temporary interim relief also in this case.
No,
So lordship,
notice has to go.
lordship, the government, the stand of the government, I'll show your lordship that suit is not maintainable. Page 33.
No, that plea you take before the appellate court.
Lordship, that plea was taken by the government himself, the forest department itself, lordship. Page 33, kindly see your
Whether
lordship.
any,
For a moment, your lordship, kindly see. The
but
then
before this court, you are against rejection of your
interim
prayer for
stay,
vacating the
stay
interim
of the temporary injunction,
stay of the.
not vacating lordship, finally disposed of injunction petition.
So we are issuing notice.
Lordship, this is
It is cultivable land.
only lordship.
Is in reserved forest, my lord. So anyway, they cannot have a right in reserved forest. But we have had recent judgments that have, my lord, set aside forest village.
Both parties may not have.
Yes, my lord.
But cultivable land, and they already recorded our name as a cultivator and homestead also, lordship. Allotment was granted already, lordship. That is also-
How reserve forest was allotted?
They are merely engaged to work for plantation activities. Sometimes, my lord, there are restoration activities of forest. So only for that they are allotted sometimes to stay there. And there's a register to keep a record of that.
We
Otherwise,
are issuing notice.
Lordship may issue notice at the same time if your lordship kindly considers, after going through the injunction order, lordship, for a moment. The injunction order, your lordship will find,
Not after, before hearing the other side.
guise of giving temporary injunction, lordship, learned trial court decided the suit finally, lordship. They allowed the prayer of the petitioner plaintiffs to possess
We'll
the
fix short date.
lordship.
Heard Miss R. Chaudhary, learned senior counsel assisted by Miss A.C. Murtaja. What is your name? S. Ahmed, learned counsel for the petitioner. Also heard Miss, who is appearing for the government?
I'm appealing for 6, 7, and 8 forest department.
What is your name?
I bought her.
Heard also heard Mr. I. Thakur appearing for responding number 6, 7, and 8, as well as Miss D. D. Burman, learned senior counsel, additional government counsel, appearing for responding number 5 and 9. This application under Article 227 of the Constitution of India has been filed by the petitioners, impugning the order dated 2/6/2026, passed by the Court of Learned Civil Justice Senior Division Sri Bhumi in Miss Appeal number 5/2026 in connection with Miss Appeal number 2026, whereby the appellate court declined to stay the operation of temporary injunction granted by the trial court, that is the Court of Learned Civil Justice Junior Division number 1 Sri Bhumi in Miss case number 609 slash
Lordship 609 of 2024.
2024 arising out of title suit number 268/2024 against the present petitioner. Issue notice. Since the government councils representing respondent number 5, 6, 7, 8, and 9, no formal notice need to be issued to the said respondents. You have received the copies.
Extra copy I will serve.
The petitioner is directed to furnish requisite numbers of extra copies of the revision petition along with annexures to the learned government councils. As regards respondent number 1, 2, 3, and 4, the petitioner shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of August.
Lordship, immediately after vacation, if possible, 13th there is a reopening, so lordship. 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20th, 21st, 22nd, 23rd, 24th, 25th, 26th, 27th, 28th, 29th, 30th, 31st, 32nd, 33rd, 34th, 35th, 36th, 37th, 38th, 39th, 40th, 41st, 42nd, 43rd, 44th, 45th, 46th, 47th, 48th, 49th, 50th, 51st, 52nd, 53rd, 54th, 55th, 56th, 57th, 58th, 59th, 60th, 61st, 62nd, 63rd, 64th, 65th, 66th, 67th, 68th, 69th, 70th, 71st, 72nd, 73rd, 74th, 75th, 76th, 77th, 78th, 79th, 80th, 81st, 82nd, 83rd, 84 if possible on 15th of July.
Will notice be served
Speed post, it may serve
July Diok. 20 July,
20 July, Lordship.
20 July. In IA also issue notice.
I have not filed, I have.
In the
In this
okay,
petition
yeah.
itself, I have stated the subsequent development.
Issue notice.
My lord, name of SC Forest may be reflected.
The name of Standing Counsel Forest Department may be reflected as engaged counsel for respondent number
Uh,
6,
6 to 8. No.
6, 7, and 8.
Lordship, may I pray to stay the impugned order of the Misapellate Court in respect to rejection of my stay?
No,
Only
no.
that part, Lordship, not the original temporary injunction. I have prayed for.
No, it will have no meaning at all.
Lordship, at least,
What will you get?
or Lordship, the misappeal may kindly be stayed so that Lordship, till decision of the injunction petition, no further progress may be.
No.
The first appellate court, Lordship.
We are fixing a short date. Let the other side appeal.
Lordship, deeply obliged.
Made please analysis. Friend is on caveat not.
Yes.
The issue raised before your lordship on a very narrow campus, lordship. Whether the last final stage of argument, my lord, whether the additional issues can be framed or not. But the facts of the case are as follows, lords. The respondent had filed this suit 21 of 2008 claiming right title interest, recovery of possession. Lord, we had filed a written statement and also counterclaim challenging the sale deeds. Lord, in respect of the same suit land, my lord, there are sale deeds in favor of either of the parties. But so far as respondent is concerned, my lord, their vendor was based in Manipur, 6 of the vendors, and an unregistered power of attorney was executed in Manipur, based on which the sale deeds have been executed in Gauhati. Now, my lord, this matter was fixed for argument, my lord. At that point of time, we filed an application.
You filed an application?
Yes.
You are?
I am defendant number 1 and 2.
Okay.
That application, your lordship would kindly take note at page
Application
154.
for what?
For framing additional issues, my lords.
Okay.
At page 154. Under order 14 rule 5, my lord, your lordship knows that provision permits even before passing of the decree, additional issues can be framed. If your lordship kindly look at the issues that we have thought for framing at para 4 at page 155.
Yes.
Whether the power of attorney dated so was authenticated by the registrar sub-registrar as required under section 32, 33, 34 and 35 of the Registration Act for the purpose of execution. Whether the registrar sub-registrar had recognized the so and so at the power of attorney at the time of executing 6 seals. But these are very important issues.
Whether pleadings to this effect was there on?
Not so far as not that is I'm coming to your lordship. Since it's an issue based on which the plaintiff has to prove its case. This is very much germane because the sale deeds have been executed on the basis of this power of attorney, my lord. It's a question of law, my lord, that the apex court has also decided. My lord, and even the trial court, my lord, has come to a finding that this issue has to be decided when I have challenged the validity. Initially, issues were framed, my lord. If your lordship kindly have a look at the initial issues that has been framed. By the order dated 7.
Where is the impugned order?
My lord. At page 169, my lord.
You, Mr. Chaudhary, you are appearing for all respondents.
Sole respondent.
Sole respondent. You will file any objection?
Yes, your lordship, before I'm coming to that point.
But as
You
far
know,
back as in
first of all-
17/11/25, but additional issues were framed on their instance.
Yes.
That your lordship would kindly have a look at page 153.
No. By this impugn order, your prayer for framing
Mine has been rejected.
rejected.
Yes.
We'll decide it. Let him file
First of all,
written objection.
Your lordship, the copy they have served is an incomplete.
Let them serve a complete copy.
Paragraph, page number 5 is missing.
5 is there.
Page number 6.
No,
is
we are
missing.
issuing
6 is
notice.
missing.
We are issuing
Your-
notice.
I'll tell you, to their submission.
6 is there. So it is there.
When
my
is the date of our?
lord. Tomorrow, on Monday, my lord.
Your-
But I'm saying that for the timing, it
Your-
will be straight for the.
Your lordship, I want to file a written of this affidavit in opposition. Your Honor, as lordship is aware, under 14 says, issues are framed on the basis of pleadings of both the parties.
Okay, we'll decide that. You
Yes.
file written objection.
Yes, sir, they have suppressed their own WS in this petition, your lordships.
Not,
They have not annexed.
not today.
Yes,
Heard Mr.
I will file a affidavit of
R.K.
this.
R. Dubey. R.K.
Ardu.
R. Dubey, learned counsel for the petitioner. Also heard Mr. P. Chaudhary, learned counsel for the sole respondent. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 11/5/2026 passed in title suit number 221/2008 by the Court of Learned Civil Judge, Junior Division or Civil Judge number 1, Kamrup Metro, whereby prayer for framing additional issues made by the present petitioners was rejected by the trial court. Stop issue noticed. Since Mr. Chaudhary has already appeared for the sole respondent, no formal steps need to be taken for issuance of notice. However, the petitioner is directed to serve the complete copy of revision petition along with annexures to the learned counsel for the respondent within 2 days from the date of this order. Place this matter again on 4th of August.
I will return affidavit in opposition.
The petition, the respondent also has also prayed for filing written affidavit in objection. The prayer is allowed. Since it is submitted at bar, that final argument in title suit number
221 of 2008.
221/2008 is fixed on
29.
June before the trial court. Stop hence till next returnable date. The trial court shall not hear the argument and adjourn the matter to some other date.
Your lordship.
One other prayer, Lord. My friend is on caveat, that caveat needs to be discharged. And since he's on caveat, I have submitted a copy of the petition with all documents.
No, he's saying that you have not
No,
furnished.
the page is only missing. 6, 7 is there. But in fact, only there.
Oh, it has been reversed.
You rectify that.
I already, I'll do that.
Not in sequence.
My lord has to discharge the caveat, Lord.
The caveat stand discharged.
Your lordship, one prayer is, as it is a whole pending cases, it's since 2008. Date may be fixed, your lordship.
Yes, I have fixed a date.
Or
4th of August.
So August already fixed.
4th of August. It is short date for us.
Deeply obliged.
4th of August.
4th of
Till
August.
4th of August, hearing will not be conducted before the trial court.
Deeply.
For admission here.
Yeah.
Net preservation.
Yes.
My lord, petitioners before lordship, you know, they are the recorded owners of a patta land pertaining to the number 233. My lord, this number is very important. Right? Now, the learned state officer, NF Railway, passed an ex parte order relating to a plot of land which is the number 21. And your lordship, the first thing is that without ascertaining whether the service report was complete, in terms of Rule 4 of the Public Premises Eviction and Unauthorized Occupants Act 1971, there is no satisfaction of the learned judge that whether service report was complete. Nonetheless, my lord, he passed an ex parte order saying that I am unauthorized occupant of the railway land and I have been asked to evict the land within 15 days.
Who passed the order?
My lord, learned state officer and a railway.
Okay.
Against that, my lord, we filed an appeal before the appellate forum, stating that the service, no point of time service was effectuated in terms of the Order 5 Rule 9 or in terms of the Rule 4 of the Public Premises Eviction Unauthorized Act. My lord, the learned judge did not believe that. Your lordship, in the top of everything, your lordship kindly see the order dated 31/7/2025, where it is reflected the address of the present petitioners, which is not correct address. Your lordship will find at page 49. In the extreme left on the top, your lordship will find Sushil by railway plot number 139. This, my lord, I do not reside there, nor is my residential address or business address. The address where my tenant resides. And what happened, my lord, after the ex parte order was passed, my lord, they served a copy to one of the staff of my tenant. And that tenant, my lord, he gave that ex parte order to me on 28 August 2025. Thereafter filed an appeal taking all this plea. And then your lordship will find the appellate order, which your lordship will find at page 62. This is a very longish order, my lord. I will not take your lordship to all that. Your lordship may kindly come to page 68. Ground number 4. Now, your lordship will find the ground is enumerated in this way, for that the learned state officer passed the impugn order in total violation of the rules of natural justice, inasmuch as the learned officer, without verifying the service report and without ascertaining as to whether the notices were served upon the appellant in terms of Rule 4, so and so and so, accepted the service of notices and proceeded ex parte. Then your lordship kindly come to page 69, ground 6. Or that the appellant, having purchased the said land along with his co-owner long back in the year 2002 from the recorded pattader by a valid deed of sale, and after duly making their names in respect of the said land, got their names recorded in the revenue record and peaceful possession of the said land all along, constructing a house thereon with due permission from the competent authority. The said land of the appellant cannot be designated as public premises simply on the basis of the claim so made by the respondent without an independent inquiry and considering the case of the appellant fairly and without prejudice. Now, here your lordship will find they are claiming that their land pertaining to dag number 21 and my land is pertaining to dag number 233. Now, without making a thorough inquiry on that, can it be decided that this land belongs to the railway land? And they say, the dag 21 has been acquired by the state of Assam on their behalf. I don't have any objection to that. If you can show that 233 also acquired, I don't have any say. Because under Article 300A, my lord, I have a constitutional right. I may not have an absolute right, but then constitutional right have to be protected. If you want to take my land for the public purpose, it is open to you. Now, they are not saying all those things. They are saying they have acquired dag number 21. How it affects my substantial right? Now, without going into all these pros and cons, they are saying the service report is complete And whatever statement I have made, the learned judge is saying that it's not believable, but that your lordship will find at paragraph, my lord, page 76, my lord, paragraph 9. It is the case of the appellant, as the lordship got that.
Yes.
It is the case of the appellant that the notice which were allegedly issued by the learned state officer were not served upon the appellant. The appellant claimed the notice were issued in the address as mentioned in the said notice, being really plot number so and so, so and so. The appellant submitted that residential address of the appellant as well as the business address of the appellant are not the same. It is further submitted that in the property which was purchased by the appellant along with his sister, they have constructed a 3-story building and one of the portion of the building is rented to one Gautam Dey. It is the further submitted that notice which was allegedly issued by the state officer as such was not served upon the appellant. However, it is an admitted fact as appears from the record that the appellant has received a copy of the MP order dated so and so, which was received by one of the staff of his tenant Gautam Dey. Admittedly, the said order was sent in the name of the address which is mentioned in the notice. As such, the plea of the appellant that notices were issued in that address was not received by him or by any of his representatives cannot be considered as true. Now the question comes, my lord, the staff of the Gautam Dey, whether he is my representative. In legal parlance, it is not, unless I say he is my agent. Furthermore, my lord, it is not my relative also. So therefore, in terms of Order 5, Rule 9, it cannot be accepted as duly served. Then your lordship kindly see at paragraph 10. If we go through the original record of the eviction case forwarded by the learned state officer, we found that on both the occasions, address of the appellant in the notice were mentioned Sri Sushil Boyd plot number so and so, so and so. The same address has been mentioned in the order dated so and so, passed by the learned state officer. So the plea of the appellant that he has received the order of eviction through one of his tenant but has not received notices issued in the same address is not believable. Well, when you say that it is not believable, then the service report that has been kept in the record, that should have been reflected how it is served. No point of time, my lord, they sent it to my residential address or my business address. This is the address where I do not stay, my tenant stays. Now that is that position. And then para 11, your lordship will see how astonishing it is. It is to be noted that the instant project of constructing third railway track between Kamakhya to Gauhati junction is a project of public interest. The Honorable Supreme Court in so and so has held that in relation to statutory provision requiring service of notice, distinction is to be made between the case where provision is for individual benefit and where the provision is intended to protect public interest. The Honorable Supreme Court has held in the case of individual interest, issuing of notice can even be waived, but in case of public interest, the same cannot be waived. The Honorable Supreme Court observed that in case of involving individual benefits, statutory requirement of issuing of notice under Section 4 of the Act can even be waived. But I could not understand in what way it can be said. The Supreme Court in that decision I tried to find. I got a decision, but in that it did not say all that. Well, can it be inferred even? I have a substantial right. It is a constitutional right. As of now, it's a human right, my lord, as the Apex Court has said. In such a situation, you want to say that notice is not required to be given because it is his public interest. My lord, I have a constitutional right in terms of Article 300A. And unless you acquire that, can you say that you will take it without the protection of the constitutional right even? Now, this is the conclusion arrived at by the learned judge without going into the pros and cons. Then para 12, your lordship will find the fact that the land under Dag number 21 was acquired by the railways for the purpose of laying of railway track has not been disputed. But why should I dispute? If you have acquired the land under Dag number 21, well and good. Now, my land is pertaining to land number 233.
No, here the question comes, the broader question, my lord. If I have stated that I have purchased that land, tag number is 233, it has been mutated, then it is required to see by making a local inspection, by making the staff of the revenue authority, that whether the land belongs to the tag number 21 belongs to me or to the railways authority. No,
No, you are not claiming DAG number 21.
No, not at all, my lord. My land is situated in Dag number 233 only. And that is required to be inspected, my lord. We have, at the time of hearing also, we have indicated to the court that local inspection is required. And the learned judge indicated, well, without that it's not possible. But then when I found the judgment, my lord, we found that all these things are vanished. So therefore, in such a situation, my lord, when I have a substantial right, the lordship kindly protect us. And after hearing the entire matter, your lordship can give a, or after discussing the entirety of the thing.
Yes, Mr. Gogoi, you have anything to say?
Lordship, it's a petition under 227 of the Constitution of India, Lordship. So, Lordship, the order passed by the appellate court, Lordship, this particular order was passed on the basis of the reports before the Honorable Appellate Court, as well as the documents which are submitted by the Lordship petitioner here in this. There is no jurisdictional error, Lordship, regarding that part. There is manifest injustice and there is no perversity, Lordship.
Perversity.
Nothing is there.
We'll examine it.
Lordship, Lordship, when my lord may kindly peruse the notice, page 51, Lordship. There is no any arbitrary action is taken by that appellate court, Lordship. Page 51, Lordship.
Yes.
Page 51, this is the notice issued by the Railway Authority, and this is the final order which was passed by the state official, Lordship, the schedule of the land, Lordship. It's a railway plot. My lord may kindly peruse that part, Lordship. Then my lord may kindly come to page 79, Lordship. Page 79 of the order of the appellate court, Lordship. Paragraph 13, Lordship.
Yes.
Paragraph 13. The case of the appellant is that he has purchased along with his sister total land measuring 1 kata under Dagnam so and so, Lordship. The appellant has enclosed a copy of the sale deed along with the memo of appeal. If we carefully analyze the schedule of the sale deed relied upon by the appellant, reflects the boundary has been enumerated so and so, so and so. So, Lordship, there is no mention regarding the railway line any site, Lordship. In the north side, so and so, so and so, so and so, so and so. Here, Lordship, the railway, the state officer passed the order, Lordship. It's clearly mentioned that, Lordship, the railway track is there, Lordship, and northern side, Lordship. So, Lordship, we are not claiming or not taking the land of the petitioner's, Lordship. It is the railway land which as per the schedule, Lordship. And petitioner land is totally in a different place of land, and he occupied the different plot of land, Lordship. This is the railway land, Lordship. And the
Now the
boundary itself,
this dispute is regarding identity of the land.
identity of the land,
He's,
Lordship,
he's claiming 223, you are claiming 21.
21, 20, when 21 is there, it's a northern side, there is a Lordship railway track. We are that full plot of land, Lordship, we are Lordship evicting, Lordship. In the petitioner's land, Lordship may kindly peruse the boundary, Lordship. There is no mention of railway land, Lordship. Railway track or anything, Lordship. Totally a different plot of land. So, Lordship, the appellate court has passed the order on the basis of the sale deed which was submitted by the petitioner, Lordship. Totally different plot of land, Lordship. If the schedule of the land, the petitioner schedule of the land, in one side the railway track is there, then the issue is totally different, Lordship. Then, Lordship, paragraph 16 also, 16 onwards, Lordship.
We are issuing notice.
What's
Heard Mr. S. Datta. Learned Senior Counsel assisted by Miss C. Agarwal, Learned Counsel for the applicant. Also Mr. K. Gogoi, Learned Central Government Council, appearing for all the respondents.
What?
All the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the judgment and order dated 7/4/2026 passed by the Court of London, District Judge, Kamrup Metro, Gauhati, in Miss Appeal number 14/2025, whereby the appeal preferred by the present petitioner under Section 9 of the Public Section 9 of the Public Premises within the Unauthorized Occupant Act 1970-71. The Learned Senior Counsel for the petitioner submits that the estate officer issued eviction notice under Section 5 of the Public Premises Eviction of Unauthorized Occupants Act 1971, and however, without verifying as to the notice was duly served in terms of Rule 4 of the rules made under the said Act, it held that the notices were duly served. The Learned Senior Counsel for the petitioner further submits that said the petitioner are claiming that the land over which the petitioner are having possession was purchased by their predecessor in interest. You purchase.
I have purchased. The
Purchased,
tell deed we have already annexed.
purchased by them, and it falls within DAG number 223 new.
233, ma'am.
233 or 23?
33. At page 36, your lordship will find that is the Jama Bandi. Column 4, your lordship will find.
Two 33 new /16 and 104 old of KP Patta number 33 new /1 and 4 old of village Borodumu, Muja Jalukbari, by way of executing a registered sale deed on 30/4/2022, whereas the land in respect of which notice under the aforesaid Act was issued was covered by DAG number 21. He submits that these pleas were taken by the petitioner before the appellate court in the appeal preferred by the present petitioner. However, same was in the appeal preferred by the present petitioner under Section 9 of the Public Premises within bracket Eviction of Unauthorized Occupants bracket close Act 1971. However, same was not considered by the trial court, by the appellate court. And as such, it arrived at a wrong conclusion, which amounts to perversity. So on the other hand, London Central Government Council submits that bare perusal of the eviction notice would reveal that the land in respect of which notice under Section 5 was issued by the estate officer is a different plot of land which was bounded on the northern side by a railway track. However, the land over which the petitioner is claiming possession and ownership has a different schedule of land. He submits that said fact has been taken into consideration by the appellate court. As regards notice,
This was all duly served because of
he also submits that the appellate court has rightly arrived at a conclusion that notice issued under the provision of Public Premises Eviction of Unauthorized Occupant Act 1971 was duly served on the present petitioners. Stop. After considering the submissions made by learned counsel for both sides, this court is of considered opinion that rival contentions raised by the learned counsel for both sides needs to be considered in this CRPIM. Hence, issue notice. Stop. Since Mr. K. Gogoi has already appeared for all the respondents, no formal steps are required to be taken for issuance of notice. However, the petitioner shall furnish requisite number of extra copies of the petition along with annexures to the learned Central Government Council. We will call for records.
The record will be necessary.
Let the records of eviction case number EO/MLG number 298/2025 be called for. This record you will have to produce,
What's it?
or it will be there in the.
All documents are there also. Now we have filed our lordship WS also, all the documents annexed there also.
As well as the records of Miss Appeal
14 of 2025 lordship.
14 of 2025 be called for from
Just Kamru Metro lordship.
the Court of London, District Judge Cambridge Metro Registry to take steps for requisitioning the records. Let this matter be listed on 5th of August.
We may be protected.
Considering these submissions made by learned senior counsel for the petitioners as well as averments made in the instant revision petition which needs adjudication by this court, during till next returnable date, the impugn order shall remain, the operation of impugn order shall remain stayed.
I only fear today before your lordship the project is national importance lordship. It is the extension of railway lines between lordship Kamakhya and Gauhati. So lordship may little earlier lordship. Otherwise, on that part only we have.
5th of August, we will try to give it. You want it before that?
Lordship may indicate that
Okay.
little earlier.
Since
Little earlier.
this matter involves
Extension of railway line lordship.
in extension of railway line between
Kamakya station to Gauhati.
Kamakya station to Gauhati station, which is of public importance. Every endeavor shall be made to dispose of this revision petition as expeditiously as possible.
Perhaps, my lord, wrong, inadvertently the wrong record was placed. That is why, designation is there, my lord. Impugned order is at page 47, my lord. Passed in a petition under order 16, rule 7, for seeking a direction to the concerned sub-register to produce the certified copy of the
Page number 47.
page 47, my lord.
Yes.
Page 40, it was rejected, my lord, only on the ground that prior to filing this application, my lord, order 16, rule 7, the petitioner filed filed 3 applications, separate online application before the sub-register, applying for the certified copy of the registered sale deeds in the month of July 2025. When the sub-register failed to furnish the certified copy, then my lord, petitioner filed the application under order 16, rule 7 before the learned court below, praying for a direction to the sub-register. May I read, my lord?
You are plaintiff or defendant?
I was the plaintiff, my lord.
Yeah, okay.
So, my lord, the case is now fixed at the stage of evidence. So, and I have challenged the, my lord, all the 3 registered sale deeds. Unless the, my lord, registered sale deeds are before the court, my lord. So, my lord, it will be difficult. We will not be able to exhibit those documents, my lord.
Your petition is under order 16, rule 7.
7, my lord.
What it says?
But the power to require person present in court to give evidence or produce documents. Any person present in the court may be required by the court to give evidence or to produce any documents then and there is there in his possession or power.
So how it is irrelevant?
But
the person has to be before the court.
Read with 151 was there.
No, this power is exercisable, may be exercised. Court may direct anybody who is present before the court to adduce evidence.
Yes, but prior to filing this application, an application under order 11, rule 14 was filed. Lordship will kindly.
That is appropriate application.
Yes, Lordship may kindly see the page 32, my lord.
Okay, we are issuing notice. Whether counterclaim is also there?
Yes, my lord. They have defendant has filed that counterclaim.
Heard Mr. N.K. Kolita, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, impugning the order dated 22/5/2026 passed by the Court of Learned Civil Judge Junior Division, Gauhati, in Miss J case number 1/2026, whereby an application filed by the present petitioner under Order 16, Rule 7, read with Section 151 of the Code of Civil Procedure 1908 was rejected by the trial court. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August.
Yes, my lord, but till then, my lord, because my lord, the case is fixed at the stage of PW evidence, my lord.
Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as averments made in the instant revision petition, further proceedings of title suit number
15 of 2022.
where have you mentioned
In their person, lordship will find.
15 of 2022, pending before the Court of Learned Civil Judge, Junior Division Bojali, shall remain stayed. Please record. Where is Mr. Sharma?
Lordship, admittedly, the written statement was filed at a belated stage, along with a petition under section 151 CPC for accepting the same. It was filed on 28/8/2024.
Who are you? You are plain.
I'm the defendant.
Okay.
So page number 80, I was filed written statement along with 151 petition. The respondent was asked for filing objection. The respondent has filed objection on 19/1/2026. Thereafter, on 014/2026, my written statement was not accepted and agreed by that impugn order. I'm coming.
Where is the impugn order?
Impugn order is at page 23. No, 83. Page 83.
How much is due to bank?
Lordship,
How much?
I have only.
It is a money
all
suit.
the entire amount I have paid. So only at least 15,000 or more have to pay out of 8.90.
Lordship, for that I have to take the instructions.
How much bank is claiming?
He claiming entire amount.
As per the plaint,
As per plain, he is claiming 8,90,000.
8,90,000.
On what basis you are saying that you have paid it?
And Lordship, I have already. No, I have already paid. I have the document. So I have, he said, annexed with the written statement also.
Where is the impugn order?
Impugn order is
Page
page
83.
83.
It is a commercial case.
Okay, for with
So-
the hope of the settlement.
But
waiting.
commercial suit, the maximum limit is 120 days.
120 days.
You
Yes.
cannot go beyond that. Neither court has power to extend.
APG, what's been said?
There are
So it's a directory provision. So it's not mandatory.
no, in case of commercial
So it-
suit, perhaps it is mandatory.
Lordship, on SCG Infrastructure's judgment of Supreme Court.
We'll issue notice. When is the next date in the TED?
Yes,
It is yesterday, it was yesterday.
It was yesterday, which for filing evidence, expertise, but evidence was not filed. They have taken time. So next date, Pitya? July, 6 on July.
You bring that case on the next day.
Yes.
Heard Mr. B. Fukon, learned counsel for the petitioners. Also heard Mr. M. K. Sharma,
And Sharma.
Mr. M. Sharma appearing for the
So
this whole respondent. This application under Article 227 of the Constitution of India, read with section 151 of the CPC, has been filed by the appellant, by the petitioners impugning the order dated 1/4/2026 passed by the Court of Learned Civil Judge Senior Division number 1, Kamrup, Metro in connection with commercial suit number 9/2022, whereby the prayer for accepting written statement filed by the present petitioner was rejected by the commercial court. Let the notice be issued. Since Mr. M. Sharma has already appeared for the sole respondent, no formal steps are required to be taken for issuance of notice. Will you file any objection?
Maybe 5 years.
Learned counsel for the respondent submits that some time may be granted to the respondent, to him, for taking proper necessary instructions from the respondent, and if necessary, to file the written objection. Let this matter will stay. 5th of August. Commercial suit we will not stay unless you have a very good case. Next, 5th of August.
5th of August.
Court hearing under order 41, item 46.
Made resolution, my lord. My lord, the appellants were the, my lord, defendants in the suit, my lord. My lord, appellants, they possess one plot of land, 1 kata 10 lesa, my lord, near the schedule land claimed by the, my lord, plaintiffs. Now, my lord, kindly sit down, my lord. First of all, the plain, lordship at page 12. The plaintiff sought for, my lord, in this suit, my lord, page 12, lordship, a suit for declaration of right, title, interest, and confirmation of possession, my lord. Page 12, lordship. So, and they have, my lord, stated that they have the possession over the suit land, my lord. Page 15, my lord, para 6, my lord.
Okay.
They and the right and possession over the suit land, they declare their possession, my lord. Now, my lord, the learned trial got what there is no issue frame as to who has dispossessed them, my lord, and the date of disposition, and my lord directly comes past the judgment and decree at page 36. My lord, kindly see the order, my lord, for recovery of possession from the, my lord, defendants. We were the defendants, my lord. My lord, in a suit for page 36, lordship, order, my lord, on the basis of foregoing discussion, the suit of the plaintiff according to on contest, it is declared, decreed and declared the plaintiffs have right, title, interest over the suit land and describe schedule A of the plain, and as such they are entitled to recover possession of the suit land as mentioned in schedule A of the plain from the defendants, my lord. My submission is that until and unless there is, my lord, any specific date pleaded in the plaint and who and how he has dispossessed, and that too without any framing of issue, my lord. And this judgment and decree, and that has been affirmed by the learned lower appellate court, my lord. It is perverse, my lord.
You took this plea before the appellate court.
Yes, my lord.
How it was dealt with?
We have stated, my lord, in our WS also. I have a separate plot of land near that, my lord. In the WS, I have stated from the father we get it, my lord, to possession interest, my lord, and we have not disturbed them, my lord.
No, in the judgment of the trial court.
Yes, my lord.
Is there no discussion about dispossession?
No, nothing, my lord. There's absolutely nothing, my lord. PW1, my lord, page 29. No, nobody has stated who has dispossessed them.
Where is the plaint?
My lord, plaint, my lord, is at page 11 stars, my lord. And
Plaint is for confirmation of possession.
yes, my lord, page 12, my lord, confirmation position. And here, my lord, this is
where is your
substantial question of law. I have framed. Also, I have recasted the question, my lord. So I am forwarding this question, my lord.
These two questions will suffice, my lord. And one ground we have taken the limitation. While you are, my lord, the court below discussing about the law of limitation of 3 years for confirmation of possession under Article 58, my lord, and the appellate court has, my lord, discussed and held the limitation is 3 years. But the while granting recovery of possession, it under Article 65, my lord, this has not been taken into account, my lord. So, my lord, these two question, I think, my lord.
Heard Mr. H.P. Neog.
B.K. Das.
Sorry, B.K. Das, learned counsel for the appellant. This appeal under Section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant, impugning the judgment and decree dated 18/3/2026 passed by the Court of London, Civil Judge Senior Division, Nogao, in title appeal number 33/2024, whereby the judgment of and decree dated 2/7/2024 passed by the Court of London, Civil Judge Junior Division, number 1, Nogao, in title suit number 141/2017 was affirmed, and the appeal preferred by the present appellants was dismissed. After going through the materials available on record and after hearing learned counsel for the appellant, following substantial question of law is formulated in this appeal. Number 1, whether the first appellate court as well as the trial court committed perversity in decreeing the suit for recovery of possession when, in absence of any evidence on record regarding disposition of the plaintiff from the suit land, as well as in view of the fact that the suit filed by the plaintiff was for confirmation of possession. Number 2, whether the trial court as well as first appellate court also committed perversity in deciding the question of limitation under section
58,
under Article 58 of the Limitation Act instead of 58 of the Limitation Act, treating the suit as a suit for confirmation of possession, whereas the relief granted was for recovery of a khas possession, and as such, whether the question of limitation ought to have been decided in terms of the provision contained in Article 65 of the Limitation Act. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post, as well as by usual mode within 7 days from the date of this order, returnable on 6th August. Any execution case filed?
My lord, execution case, my lord, that has not been filed. However, my lord, since the honorable court is also heading for, my lord, vacation, my lord, till the returnable date, my lord, that may be stayed. I will text
in
them.
IA, issue notice until returnable dates, the execution of the impugned judgment and award shall remain stayed.
Deeply obliged.
Order 41, Rule 5 ka orders. Yes.
Obliged.
Item 47.
May I please, your lordship? My lord, the present appellant before your lordship entered into a agreement for sale of land on 30/11/2012, my lord, and the patta which was mentioned is, my lord, patta number 44, together with dag number 221 and 410. That agreement was entered into, my lord. So far the respondents are concerned, my lord, performer respondent number 1 is the brother of the main respondent. Now I entered into the agreement with the respondent number 1, with not with the performer respondent, but they being the brother, my lord, the respondent asked me to execute the sale deed in favor of his brother. After execution of the sale deed, my lord, he filed a suit, impleading no doubt his brother filed a suit that instead of selling this land, I agreed to sell the land pertaining to patta number 177. And that, my
In
lord,
respect of which land sale deed was executed?
sale agreement was in respect of patta number 44, my lord.
44.
44.
And sale deed was executed
In respect of patta number 44 itself.
He filed a suit
He filed a suit thereafter, my lord,
stating that
taking the plea that I had entered into an oral agreement with him to sell the land pertaining to patta number 177.
okay, oral agreement.
Oral agreement. But the oral agreement being not proved. Not proved. Then, my lord, the trial court dismissed the suit of the plaintiff being TS number 14/2014. It was dismissed.
14 of 2000?
14, my lord. 14 of 2014.
Okay. Yes.
It was dismissed on 36/2018.
Yes.
36 to thereafter, my lord, the respondent number 1 filed an appeal being RFA number 46/2019, but due to change in pecuniary jurisdiction, it was sent back, and this was registered as title appeal number 5/2023.
Okay.
Here, first appellate court, my lord, decreed the suit on 21/5/2025.
Reverse the trial court's judgment.
Yes, reverting the trial court judgment.
Okay.
Reverting the trial court judgment. But with the finding that there was no oral agreement with me to execute the sale deed in respect of patta number 177. That finding is already there, my lord.
Then what was decreed?
It was decreed, my lord, that I am to pay rupees 5,63,000 to him. If I can take your lordship to page number page number 75, my lord.
What is the substantial question?
Substantial question, your lordship will be pleased to find at page number 10.
Yes.
After grounds, my lord. My lord.
What is section 19?
Section 19 is there. It will come along with section 20, my lord. 20 of the specific relief. It should be good.
Oh.
What
What is
there?
there?
A judgment to that effect also.
What is there?
My lord, first head note, my lord, I would like to read before your lordship. Contract and a specific relief. A specific relief act 1963, section 19B, 10 and 20. A specific performance of agreement to sell immovable property when property is sold to subsequent transferee with notice of the prior agreement to sell. Proper form of relief in such case reiterated. Cancellation of the sale deed executed in favor of a subsequent purchaser held it is not necessary for the prior buyer agreement holder to seek cancellation of sale deed executed in favor of a subsequent purchaser. It is sufficient to implead subsequent purchaser in suit and seek relief of a specific performance against original owner and also seek direction to subsequent purchaser to join in execution of the sale deed in order to completely convey title to the prior buyer agreement holder. This is, so my lord, this
I have not understood anything. what it says.
Yeah, my lord, my brother has entered into the agreement for sale with me.
Yes.
Now, my brother himself said that instead of selling the property to me, you sell it to my younger brother. You sell it to my younger brother. That was done, my lord. So the specific relief which he ought to have sought is that both the persons, those who are impleaded as defendant and pro forma defendant, brother and myself, my lord, proposed seller, should execute the sale deed in favor of the, intending purchaser, with whom I had already entered into an agreement in the year 2000.
Beforehand.
Yes.
Okay.
So that.
He was also replaced.
And the person with whom I had entered into the sale agreement, my lord, he became the witness to that sale deed. But subsequently, he filed another suit against me, stating inter alia that I had paid the money for some other land. But that is not proved, my lord. That is not proved. So, my lord, the substantial question of law at page number 10 will be A and particularly C, my lord. That there must be some readiness and willingness to purchase the property. Oral agreement, my lord. He states to be the oral agreement.
Heard Mr. A. Sattar, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant Shri Subroto Patangya, impugning the judgment and decree dated 21/5/2025 passed by the Court of London, Additional District Judge FTC Sonitpur, entitled Appeal number 5/2023, whereby the judgment and decree dated 30/6/2018 passed by the Court of London Civil Judge Sonitpur, Tejpur, entitled suit number 14/2014 was set aside and reversed. Upon consideration of the materials available on record and after hearing learned counsel for the, after considering the submissions made by learned counsel for the appellant, following substantial questions of law are formulated in this appeal. Whether the first appellate court has committed perversity in decreeing this suit of the plaintiff without considering the provisions contained in Section 19 and 20 of the Specific Relief Act 1963. Stop. Number 2. Whether the first appellate court committed perversity in decreeing the suit of the plaintiff and setting aside the judgment and decree of the trial court without there being any materials on record to show the compliance on the part of the plaintiff of Section 16 within bracket C of the Specific Relief Act 1963. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of August.
Well,
you have stay application.
My lord, yes, my lord. And in paragraph number 10, my lord, I have already mentioned the title execution case number which is going against me. Para number 10 at page 8.
Lord Mr. Isabel, this interlocutory application under Order 41 Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant in connection with the connected RSA number 62/2026, praying for stay of execution of the impugned judgment and decree dated 21/5/2025, passed in title appeal number 5/2023 by the Court of London, Additional District Judge FTC Sonitpur. Stop. The learned counsel for the appellant has submitted that the aforesaid judgment and decree has been impugned by the present applicant in the connected RSA number 62/2026, and same has already been admitted by this court. He further submits that in the said appeal, the substantial questions of law have been formulated and notices have been issued to the respondent. He also submits that in the meanwhile, the respondents have already initiated an execution proceeding, being title execution case number
35/2025.
35/2025, and therefore prays that the execution of the impugned judgment and decree is required to be stayed. Stop. Considering we are issuing notice and staying also.
My lord.
Issue notice. However, stop. However, in the meanwhile, considering the submissions made by learned counsel for the applicant, further proceeding of title execution number 35/2025 pending before the Court of Learned Civil Judge, Senior Division.
My lord, this decree was by the FTC court, my lord. First of all, court is the FTC court.
Where is the execution case pending?
Civil Judge Senior Division.
Civil Judge Senior Division.
Senior Division, Sonitpur at gate.
Shall remain stayed till next returnable date, list according. I have formulated two substantial question of law and fixed the matter for final hearing on 6th of August. And till that date, the execution case shall remain stayed.
But we want to file one more.
I don't know whatever you want to do. I mean,
Much.
Item 48.
Item number 48. Yes, Mr.
Against reversal, my lord, this appeal has been prepared. Lordship, basically this appeal has been prepared against the impugned judgment and decree. And that is, my lord.
You were plaintiff or defendant?
I was the defendant. The facts behind the appeal is such. The respondent as plaintiff filed a suit before the Learned Junior Division, the Civil Judge Junior Division, Gauhati, seeking the declaration of right title interest and recovery of possession, as well as partition, and also for specific performance of contract. Basically, so far the property relates to the said suit was concerned. That was the leased property, and the right title interest and declaration of right title interest has been dismissed, refused by the Learned Trial Court by holding that since the property is admittedly a leased property, so over that property, declaration of right title interest cannot be declared. Accordingly, suit was dismissed. Against the
suit was dismissed.
Suit was dismissed.
Okay.
Basically, against that matter, appeal has been prepared first of it. The Learned First Appellate Court below has declared the right title interest over the property, suit property, and also it was partition. And so far, that part is concerned, my lord.
How it dealt with the question that the property was leased property?
Yes, that is the admitted fact, my lord.
How appellate court overcome that?
Well, because the learned first appellate court hold that since the admittedly the property is a leased property, but it will covered under the Assam Temporary Settled Areas Tenancy Act, my lord. Because my lord, the findings of the learned appellate court is such that since the property is a leased property, so heritable right has been, my lord, conferred to the heirs of the deceased, my lord.
So whether the plaintiffs were claiming to be occupancy in it?
No, my lord. So far that part is concerned, I submit, my lord. The plaintiff and the, my lord, defendants, my lord, or the brothers, my lord. They are, my lord, legal heirs of Krishna Sonar, and Krishna Sonar had been occupying during his lifetime, my lord, a part of plot of land, my lord, under the Jadav Rai, my lord, grant, my lord, as a tenant, my lord. After his death, my lord, the four brothers had been, my lord, inherited their property, my lord, as occupant, as tenant. According that has been continued, and in the year 2014, amongst the brothers, partition deed was, my lord, executed, and in view of that partition deed, my lord, they have been, my lord, occupying their prospective proportion of land, my lord. And so far that part is concerned, my lord, the present respondent has admitted as regards to the admission and execution of the partition deed, and basing on that partition deed, he sought the relief of specific relief of contract, and that was executed in the year 2014. And over that property, he has sought the right title interest, declaration of right title interest, which cannot be, my lord, because it is the property belongs to other person, my lord, who is not a party in the suit, my lord. Accordingly, my lord, I have formular substantial question of law at page, my lord.
Trial court dismissed the suit.
Dismiss the suit, basically on the ground.
Heard Mr. M.K. Sharma. London. This is item number?
What happened?
Learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1973 has been preferred by the appellants, including the judgment and decree dated 27/4/2026 and 4/5/2026 respectively, passed by the Court of Learned Civil Justice Senior Division Karbi Anglong in the title appeal number 1/2025, whereby the judgment and decree dated 1/11/2025, passed by the Court of Learned Civil Judge Junior Division Bokajan Karbi Anglong in title suit number 2/2023 was set aside and reversed, and the appeal filed by the present respondent was allowed. After considering the materials available on record, as well as after going through the materials available on record, as well as after considering the submissions made by learned counsel for the appellant, following substantial questions of law are formulated in this appeal. Stop. Whether the First Appellate Court committed perversity in decreeing the suit of the plaintiff, ignoring the fact that the property over which the right, title, and interest of the plaintiff was declared by the appellate court was admittedly a leased property, and the owner of the said property was not made. Who was the owner?
One Borua.
He was the party in the suit.
That part is concerned, my lord. The First Appellate Court finding is such that since the dispute in between the brothers is not a necessary party, I am not also not on that, my lord. I am also on that the lease property cannot be.
To continue, last line to continue. Stop. Last line. And the end or for a continue. Whether the first appellate court committed perversity in not taking into consideration the admission by the plaintiff in what admission?
Execution of partition deed in respect of partition of the property.
Admission by the plaintiff regarding execution of this suit property by partition deed number dated 7/4/2014, which was exhibited as Exhibit 3/Exhibit B in the trial. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of August. Any IA is there?
I is there for suspension of operation.
Heard Mr. M. K. Sharma, learned counsel for the applicant. This interlocutory application has been filed by the applicant under Order 41 Rule 5 of the Code of Civil Procedure in connection with regular second appeal number 85/2026, praying for stay of execution of the judgment and decree which has been impugned in the connected appeal. Stop. Learned counsel for the applicant submits that in the connected appeal, substantial question of law has been and the appeal has been admitted. Hence, the execution of the impugned judgment and decree is required to be stayed during pendency of the regular second appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on what was the date? 6th of August. In the meanwhile, considering the submissions made by learned counsel for the applicant as well as considering the averment made in this interlocutory application, any execution case has been filed.
As of now, no notice has been received by us.
Further,
But so far,
the execution of the impugned judgment and award shall remain stayed. List accordingly.
one other submission. So far, liberty may kindly be granted to us so that at the time of hearing, I may also find another substantial question also. That liberty may be given at the time.
No, that is, law is clear. Court may formulate any substantial question of law if required.
Right. That
But
observation may be. It will not.
observation is not necessary.
That's
Item 11.
I love it.
May I please your lordship? My lordship, here what has happened? We as a defendant, lordship, we filed an application under Order 7 Rule 11 as a defendant for rejection of the plaint.
Okay.
Now, that Order 7 Rule 11 petition, your lordship will find in page number 69. Followed by this petition, lordship, the trial court in the title suit, Annexure 7, page 78, lordship may kindly have a look, lordship. Lordship kept, the trial court kept in abeyance the further proceeding of the title suit. In the title suit as well as in the miss case, that is in page number 79, annexion number 8. Thereafter, what happened, Lordship? Plaintiff filed a petition, annexion 9, page 80, falsely stating that an injunction order has been granted and that injunction order is required to be extended. I just read out that part, Lordship will kindly see. That is honorable court, that is, I am on page number 80, annexion number 9, Lordship. That this honorable court by the order dated 23/12/2025 passed in aforesaid miss case number 572/2025 restrained the opposite parties defendant, their workers, employees, and associates from dispossessing the petitioner from the scheduled shop room premises and from disturbing the peaceful possession and occupation of the petitioner thereon over the scheduled property in any manner till next date of hearing. There is no such order. 23/12/2025 does not speak of any such order, Lordship. That aforesaid order dated 23/12/2025 is required to be extended for protection and preservation of the suit property. This petition was filed belatedly in our absence, Lordship, on that day. The moment we came to know, we filed an objection, Lordship. You will kindly see that impugned order. That objection is very clear. We objected that there is no such order, and therefore, since the suit is kept in abeyance, therefore no order can be passed in the title suit as well as the Miss J case. But what the learned court did, the learned court vide annexure 10, page 83, Lordship, may kindly have a look, Lordship. The learned court passed an order in the Miss case, that is the injunction suit, as well as in the title suit, holding that in respect of electricity connection, there is no dispute regarding any electricity connection because that electricity connection was never disconnected. So this, by this impugned order, Lordship, we feel that this
Where is the order dated 23/12/2020?
23 annexion number, Lordship will kindly come to annexion number 3, Lordship.
Page number?
35 to 37. Nothing is there. Rather, we have been directed to give an objection in respect of the same. OP also refused to receive the rent, so and so it is written down. However, considering the fact that requirement of the electricity is a basic requirement, landlord is directed to restore the electricity. It was never disconnected, Lordship. It was a false statement altogether. Petitioner is directed to issue notice to the OP within 3 days of this order. The petitioner is also to comply with the provisions of Order 9, Rule 3, A and B, but no injunction was granted. Now, Lordship, what has happened by this impugned order? Although the suit was kept in abeyance, give me the book. Although the suit was kept in abeyance, Lordship, the trial court below has passed an order, which the trial court ought not to have been passed. That is in page 84, Lordship, may kindly have a look, Lordship. Annexion number 10. In that, the trial court is observing, Lordship. Now, although the injunction case has been kept at abeyance, the interim protection is given only to avoid any inconvenience to the OP in respect of right, which is a basic requirement of life. Now, there was no disconnection of any electricity, Lordship. Now, Lordship, may kindly come to Order 39, Rule 1. What does it say? CPC, Lordship. I'm on that, Lordship. Order 39, Rule 1 says, Lordship, wherein any suit, meaning thereby, the suit has to proceed, but the suit was kept in abeyance on ground.
But it is there. It is in abeyance.
In abeyance. So my submission was that, Lordship, that since the suit was in abeyance, no order ought to have been passed in that particular suit, which the court has denied. That court has passed that order.
In Miss case.
In Miss case as well as in title suit. In Miss case, they are writing that no, court is saying no, it is only in respect of the electricity. But electricity here is not a question. Lordship may kindly look into their petition, Lordship, what they have written. Once again, I will take your Lordship to their petition.
No. What is relevant is order dated 23.
23/12, Lordship will kindly see there is no injunction order. Neither there is any such order that they will not be outstayed or something in that regard. That is in page 35 to 37, Lordship. You will kindly have a look once more, Lordship.
No, you were directed to restore electricity connection.
Falsely stating, Lordship, because that was an ex parte order, Lordship. We were absent. We never disconnected. We have therefore written in our written statement that we have never disconnected.
No, whether 23/12/2025 order was ex parte.
Yes, Lordship, because that day we were not present. It was an order, the fast date order, Lordship, on the injunction order. So we said
You have not disconnected electricity. Then how it matters?
no.
Eh,
Question is not that, Lordship. Question is
Legality.
when the suit is in abeyance,
Legality.
whether legality and illegality, propriety, Lordship.
Okay, then we are issuing notice.
Lordship may kindly stay also, Lordship.
No stay.
Lordship, they will continue doing all this perversity, Lordship. Where we'll go.
No, what perversity? You are saying that you have not disconnected the electricity.
Lordship will kindly see it will go an indulgence to them. Why? Because the plaintiff has filed a false petition altogether. Annexion 9, Lordship may kindly have.
No, that's.
Annexion 9, they are saying.
Okay, let them appear. Heard Mr. A. Bhattacharya.
Lordship may kindly.
What would be the impact of staying?
Because Lordship, they are placing false petition before the
No,
court.
how it will benefit you?
Because what has happened, Lordship will kindly see. Let me show you, Lordship. Lordship, kindly see the first line, Lordship, on 22/5/2026.
No, accepting that they made a false statement.
Lordship, had we not been there, Lordship, kindly see, I will show you, Lordship, very interesting part. 83, kindly have a look, Lordship.
Mr. Bhattacharya, I want to understand how stay will benefit you.
I am satisfying that part, Lordship. Lordship may kindly come to 83 first, Lordship. Lordship may kindly see case number 133/26 in respect of electricity connection written in hand. Letter on. That means the court was being taken away by the misleading statements.
Okay, we'll examine, let them appear. Heard Mr. A. No, you have failed to satisfy.
Why I'm saying Lordship may kindly see, Lordship may kindly see, Lordship 83 for a moment of time, Lordship.
No, what you want to stay?
What I want to state, Lordship, on that day.
No, what you want to stay?
I want to stay the procedure.
You are saying that electricity has not been disconnected.
Lordship.
So what will be the impact of stay? There will be no impact.
Why I'm submitting this, Lordship? I have a reason for that. Lordship may look one by one. Lordship may first come to an action.
Now you are going to disconnect.
No.
Then
never. We have never disconnected. We'll never disconnect.
Heard Mr. A.
Lordship may kindly have a look to
No,
number 9, Lordship, for a moment, Lordship.
No, A. Bhattacharya, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 22/5/2026 passed by the Court of Learned Civil Judge Unit Division number 2 Kamrup Metro in Misja case number 572/2025 in connection with title suit number 3848/3. Yes.
Lordship may kindly see later on at about 4 p.m. Kindly see that part, Lordship.
Yes, let them appear.
Because what I'm saying, Lordship, earlier the court has already passed an order on their false pleading that injunction order is hereby extended. When we appeared and showed to the court that there is no injunction order, then court writes in the pen with a pen in respect of electricity connection. That is how the court is functioning, Lordship may kindly have a look, Lordship.
That is number 348/2025. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon respondent by speed post as well as by usual mode by within 7 days from the date of this order, returnable on 5th of August. Let the scanned copy of the records of Miss J case number 572/2025
as well as TS
as well as scanned copy of the title suit number 348/2025 be called for registry to take steps for requisitioning the scanned copy. List accordingly.
In the meantime, Lordship may kindly, because Lordship may kindly see how the court is functioning.
I am not convinced.
Because why am I saying Lordship?
Wait for their appearance. Let them appear. Let them tell a different story.
They will not tell a different story, Lordship, because they have already filed a petition. Lordship may kindly see. Absolutely.
No, Mr. Bhattacharya, they are entitled to get notice. I am only issuing notice. Let them.
ISA will to 4 of 26.
So after some time.
Production list item 2. CRP level 299 of 26.
But may I please announce? But I'm agreed by an order by passed by the Civil Judge Junior Division at Singimani, by which the attachment order has been issued of the property of the petitioner number 1. But Lordship may kindly take up my petition, page 18. Page 18. Page 18 is the execution petition.
Yes.
Lordship, page 18, kindly see, the respondents are, the defendants are, again, the petitioner number 1, 2, 3, and 4, they are the petitioners before this honorable court now. And the defendant number 5, the Mankachar PHC, represented by the superintendent IC, that is under the health department, they are the defendant number 5 and the judgment debtor number 5. And here, he is respondent, the health department is the respondent number 9, here. Kindly, after the execution case was filed, it was filed before Dhubri. Earlier, arts file, South Sarmana Mankasar was a subdivision. At that point of time in 2014, it was filed in Dhubri. Subsequently, kindly come to page number 21. It was by an order dated 2/3/2017 at top, Lordship will find the case record received on transfer from Court of Munsif number 1 Dhubri by letter number so and so dated 1/3/2017. The same is renumbered as title execution 3 of 2017. It was by Munsif Hatsingimari. After that, the notice has been issued, and kindly come to page number 23. Page 23. Order dated. Kindly take up order dated 16/8/2018. The JD number 5. JD number 5 is the superintendent of the model hospital, that public health center. The scene petition number 27/18 filed by the JD number 5, praying for another date for filing objection, and also seen the W2 message sent on behalf of the JD number 1, 2, 3, and 4. The present petitioners praying for another date for appearance due to prevailing law and order situation in connection with the Independence Day. But in fact, what I am trying to show that all the judgment debtors, the petitioners, and the respondent number 9, JD number 5, they are before the honorable court. Kindly come to page number 24. All along the judgment debtor number 5, respondent number 9 here, they appeared before the executing court on 8/4/2019. Kindly see, the judgment debtor number 5 has appeared before the court. He has issued necessary instruction to ensure execution of the writ. Then kindly see the next order.
What was directed?
Kindly, the direction is, Lordship will find at page number 20. This is the execution. In fact, in the title suit, the decree has been the suit has been decreed in favor of the plaintiff.
What was the suit for?
Suit was for declaration of right, title, and interest, but the honorable court has said that since there is a hospital already built up, it is going on, so therefore the land is not to be recovered, not to be handed over, but the value of the land has to be given to the plaintiff. Kindly come to page number 20. That is the part of the execution petition. Kindly see para 1, page 20. Page 20. Against column number 10, they have prayed. I pray for execution of the decree passed in title suit number 434 of 2007, declaring right, title, and interest of plaintiff and myself, that is pro forma defendant number 1 and so counterclaimant number so over Schedule A land, and entitled to get value of the suit A schedule land from the defendant judgment debtors after execution of a sale deed on payment of the present government market value of the suit. a scheduled land in favor of the plaintiff and myself, that is so and so. So their prayer is, my lord, for payment of the execution is not to the extent of payment of the suit, the value of the suit land. Then, my lord, kindly, my lord, I take your lordship, my lord, to page number 24 to show that the judgment data number 5, they, my lord, appearing, my lord, before the court. I have already read order dated 8/4/2019. Kindly, my lord, come to order dated 17/5/2019. Again, the judgment data number 5 has forwarded copies of his written communication with the judgment data number 2, as per which the process of execution is officially underway. So also seen copy of the letter forwarded to the JD number 2 from the Joint Director of Health Services, Dhubri. So decree holder to take fresh steps in this regard. Lordship may kindly, various orders are there, my lord, since 2017-18, my lord, various orders are there. All along the steps taken by the JD number 5, the health Joint Director of Health Services, my lord, it is reflected. Kindly come to page number 34, annexure 7. My lord. Page 34, my lord. Have a lordship.
Yes.
My lord, page 34, this is a letter by the ADC South Salmara Mankasar to the Joint Director Health Services South Salmara. By this letter, my lord, the ADC has requested the Joint Director that with reference to the subject cited above, the undersigned has received a copy of the order dated 6/8/2024, passed in title execution number 3 of 2017 by the Honorable Civil Judge Junior Division Hatsingimari. Therefore, in view of the above, you are requested to take immediate necessary action to satisfy the order as passed by the Honorable Civil Judge Junior Division Hatsingimari as early as possible to meet the end of justice, and also action taken report may be submitted to the underside by the next date fixed, that is on 28/8/2024. Along with this letter, my lord, kindly, my lord, page 35, this is the notice of the Honorable Court. This was annexed, and the order of the Honorable Court at page 36. This is a part of the letter of the ADC, 6/8/2024. Then, my lord, after that, on the date fixed, that is 28/8/2024, that order lordship will find at page 39. The Honorable Court has taken the learned executing court has taken note of our letter dated 22nd of August 2024. Well, page 39.
Yes.
The learned court has said, well, both the judgment decree holder and the JD sides are represented. Report of notice to DC South Salmara Mankasa returned upon duly served. I have heard the learned counsel appearing for the DH and as well as the learned government pleader. Learned counsel for the DH submitted that the DH is an ailing person and decree be executed sooner so that the decree holder can enjoy the fruit of the decree. Learned GP appearing on behalf of the JD 5 petition number so and so dated so and so submitted that the process for execution of the same is underway, and he has annexed a copy of the written communication from the office of the DC to the Joint Director Health Services by letter number so and so dated 28 August 2024. That letter I have read, my lord, at page 34. With receipt of the with respect to this case, wherein the Joint Director of Health Services South Salmana Mankasar is requested to take immediate necessary action to satisfy the order passed by this court and to submit a report to them. The learned GP, however, apprised this court that no such report is received from the Joint Director of Health Services till date. Lordship may kindly come to the next order, that is at page number 42. Thereafter, on 20th of May 2025, my lord, before the learned executing court, the Joint Director Health Services, my lord, today, the Joint Director of Health Services Mankasar has submitted a copy of communication addressed to the Director of Health Services Assam, Hengarabari, Gauhati. Additionally, a written communication from the Director of Health Services Assam, white memo number so and so dated 17/5/2025, has been submitted before this court. Perusal of the said communication reveals that the Director of Health Services Assam has sought suggestion from the competent government authority regarding the arrangement for payment of market value of the decretal land to the decree holder in compliance with the decree passed by this court. So, my lord, they are taking steps for payment of the decretal amount before the learned executing court. From the above, it appears that interdepartmental communication is presently ongoing among the government judgment debtors concerning execution of the decree. Today, the learned government pleader has also filed a petition praying for time to make payment to the decree holder in compliance with the decree. However, none appeared for hearing on petition number 2 of 2024 dated 5/1/2024 filed by the decree holder under order 21 Rule 30 CPC and no steps have been taken by the DH. But in the meantime, the decree holder has filed an application under Order 21 Rule 30 for attachment of the property. So that petition kindly Lordship will find at page number 44, Annexure 10. So this is the service copy served on us, petition under Order 21 Rule 30. Here, my lord, they have prayed for the prayer of the decree holder under Order 21 Rule 30 of CPC.
This petition has not been heard.
This petition at that stage was not heard, but now, my lord, since the amount has not been paid by the health department, this petition order has been passed in this petition now.
Where is the order?
I'm taking your lordship. But kindly for a moment, my lord, the petition starts at page 44. Lordship may kindly see, my lord, page 46. The list of properties they have mentioned there, they have, my lord, indicated the properties of the district commissioner at page 46.
Yes.
But list of properties that the office chair of district commissioner South Salmara Mankasar, all office vehicles of district judgment letters, the properties they have indicated, this belongs to the district commissioner's office.
But it is government property.
It is government property, but
Government is the decree holder, is the judgment debtor.
see, the land is under occupation of the respondent number 9, the judgment debtor number 9.
Respondent number 9 is one of the government department.
That's true. That's true. That's true. But kindly appreciate, but joint director of health services and the director of health services, they are in the process of the making arrangements for the fund.
No, government cannot shift blame to one of its department. Since 2017 onwards, only communications are going on. But you have not paid the decretal amount. Neither there is any appeal.
That is true. That's true. That's true. But the thing is, my lord, ultimately the money has to be paid, and it is under process. That is also a fact, my lord, that has to be considered.
It is process for last 10 years.
Well, that's well, in fact.
Now what do you want?
I will kindly see the impugn order. Before that, my lord, the impugn order, my lord, at page 68, my lord. In fact, before that, kindly see order dated. Kindly lordship, permit me to take your lordship to the order dated 26/2/2026 at page 60. I'll take your lordship to the impugn order. Before that, kindly come to page 60.
Yes.
Well, on 26/2/2026, the show cause reply was directed. That order is there. I'm not taking a lordship at this stage. The show cause reply has been filed by the additional district deputy commissioner South Salmara. Hard perused the reply and the document annex. It is admitted therein that the decretal amount of rupees 15,26,250 is 15,26,250 is payable to the decree holders. It is further stated that the correspondence has been made with the Director of Health Services and the government for allocation of funds. However, no material is placed on record to show sanction of fund or any definite timeline for payment. The decree was passed in the year 2014. The execution petition has remained pending for several years. Since 9/7/2025, repeated opportunities was granted to file show cause reply. Even now, reply only indicates interdepartmental correspondence and does not disclose any concrete steps taken for sanction of the decree. Then finally, kindly come to para 8. It is made clear, Lordship has said that it is made, the learned executive court has said that it is made clear that in default of the deposit within the said period, 45 days time has been given, and said that it is in default of deposit within the said period. Petition number 2 of 2014 under Order 41 Rule 30, that petition at page 44 I have shown, Malad, shall be allowed an appropriate attachment proceeding shall follow without further opportunity. Then subsequently, Malad, Lordship may kindly come to the impugn order.
Which order you are impugning?
At page 26/5/2026, page 68. This order was passed. Malad, the order says, Malad, that para 3, it appears that despite sufficient opportunity having been granted, the defendants have failed to comply with the decree order passed by this court. The record further reveals that the decree remains unsatisfied till there. Mere appearance of the so-and-so with due compliance of the directions of this court cannot be a ground for indefinitely withhold the decree. But accordingly, in exercise of power under relevant provisions of Code of Civil Procedure, let attachment issue against the properties accounts of the judgment debtor of the concerned department to the extent necessary for satisfaction of the decretal amount. And the Nazir has been directed to take steps for issuance of writ of attachment. But I am agreed by this, Malad, at this stage, kindly see, Malad, where the steps have been already it is, the process is going on. And the respondent number 9, the judgment debtor number 5 is a party here, Malad. My friend appears for them, Malad. Well, he can have, they can very well apprise the status of payment, Malad. 15 lakhs 26,000 rupees is to be paid.
Since last 9 years, you are appraising the court only the correspondence between interdepartmental correspondence. This cannot go on forever.
No, absolutely, Manoj. But the thing is that, Manoj, the deputy commissioner, in fact, the judgment debtor number 5, who is before the court, and their
If government is not able to satisfy the decree passed against it for 9 years without there being any appeal.
But at this stage, Manoj, instead of proceeding against the judgment debtor number 5, the attachment has been sought to be made, Manoj, against the petitioner number 1. The entire district administration will be jeopardized, Manoj, if the attachment is.
So you take steps to pay the decretal amount.
Lordship may at this stage, Manoj, kindly give us some relief, Manoj, some relief, Manoj.
What relief?
But,
You assure this court that you will make payment.
Manoj, kindly appreciate, Manoj. The judgment debtor number 5.
No, government appears to have taken things for granted. The decrees against government for last more than 12 years after the execution case is pending since 2014.
But various developments are there. But in the meantime, it was in Dubri, it was got.
No, the decree holder is not concerned about the interdepartmental correspondence.
That's true. But in a way, Malad, kindly consider the predicament of the present petitioners. In fact, the judgment debtor number 5 is before the executing court. And the executing, in fact, they are appearing before the executing court, and executive court has considered the steps taken by them.
He is under your control.
No, Malad. The director of health service is not under the control of the DC.
But a government department.
Kindly see, Malad, here the petitioner is the district collector.
You are also the judgment debtor.
But they made party. But in fact, I have suggested that.
The decree is also against you. There is no
Malad, at that,
relief. He can go for execution of decree against any of the judgment debtor.
That's true. But because at the appropriate stage, Malad, they have not raised any objection. Because it was filed in 2007. Decree was Malad, passed in 2014.
Is against you. The judgment debtor may choose to.
Well, I have suggested them to file appropriate appeal or whatever petition. Well, I have suggested them already, because they have no role to play. In fact, when the decree stands as on today, I cannot, Malad, although I have submitted, Malad.
You satisfy the decree. Take steps for satisfying the.
Malad, Lordship may at this stage kindly protect us and issue notice in the matter, Malad, so that the respondent number 9.
I will not grant any stay.
Malad,
No stay.
Malad, kindly, Malad, consider, Malad,
No, had there been a case where government, some kind of diligence would have been shown by the government for last more than 12 years.
In fact, Malad, in 2024 August itself, it has been categorically, Malad, apprised to them, Malad, and they have, before the honorable court, the joint director appeared and they have said that they are taking the steps, but and for their default, kindly consider, Malad, the district administration should not be.
You are also the judgment debtor.
That's true. But kindly see the arrangement is there, Malad. Internal.
You could have taken steps for ensuring that the decree is satisfied.
The fund position, it cannot be like that, Malad. The financial norms are there.
Then face the consequence.
Malad, kindly, that is why, Malad, we are before your lordship. Kindly, lordship, kindly see what the difficulty on the part of the present petitioner. My lord. Ultimately, the financial norms doesn't permit him. My lord. When the respondent number.
You are saying that there is no way to satisfy the decree.
No, there is a way. There is way.
Instead of making interdepartmental,
No,
only interdepartmental,
No, there is.
everyone is shirking his responsibility by sending a letter.
Here, therefore, my lord, I have taken your lordship to various communications and the orders to show that the judgment letter number 5, they are taking positive steps. So the executive court can very well, my lord.
No, the adjective positive step will not impress this court. What positive step? For last 12 days, 12 years, you have not done anything.
The respondent number 9, my lord, here in this petition. Let them come up, my lord. To what extent, my lord, their arrangement for making arrangement for fund. At what stage they are, my lord? Because it is not under our control. The DC cannot control the director of health services.
Oh, the decree holder is not concerned about who is under whose control. He has a decree against you also. You are the judgment debtor. He can go for execution against any of the judgment debtor. And you are one of the judgment debtor. You cannot say that judgment debtor number 5 is responsible to satisfy the decree. There is no stay, no interference by any appellate. Decree stands as a.
That's true. That as on today, my lord, I can't deny, my lord. But the
It extends the time.
lordship may kindly, my lord, kindly extend the time. At this stage, my lord, kindly protect us to that extent.
Give assurance that you will satisfy the decree. You will take steps for satisfying the decree.
My lord,
Otherwise, why protection should be granted to you, one of the judgment debtor? Where will the decree holder will go?
my lord, decree has to be satisfied. There is no doubt. That it is for sure, my lord. And when the
And you are aware that you are the judgment debtor. Someday you may have to face execution.
But in fact, regular steps are being taken, and regularly, my lord, regular steps are being taken. With
What steps?
My lord, the communications are
Communication
there.
will not.
Instructions are there, my lord.
Are not such. If communications are not yielding any result, it is of no use for the decree holder.
In fact, kindly appreciate, my lord, that the highest authority in the health department, the director, they are my lord, they are in the picture, my lord. In fact, they are there, my lord. At least, my lord, they can apprise the executive court or this court also what steps they have taken and how within how much. But for their my lord, the inaction, the district administration should not suffer, my lord. That is my humble prayer with you.
One government department is blaming other government department.
In fact, I would like to clarify, my lord, this is not a blaming, my lord. In fact, I'm not blaming anyone, but it is their duty, my lord, to respond to that. Kindly appreciate, my lord, to that extent. In fact, the order, the records of the execution code, which I have annexed, my lord, the
decree against the state of Assam is also a judgment debtor.
State of Assam represented by the district collector.
Yes, you are a judgment debtor.
That's
You
true.
know that what responsibility of a judgment debtor is.
That's true.
Yes, you are appearing for respondent number 5. What are you doing?
Lordship, here I just have this communication, Lordship. Here
No, we are not at all concerned about interdepartmental communications.
Yes.
Otherwise, we are not going to stay.
No, Lordship.
Had this been a fresh execution case, the question would have been different. This is a 12-year-old execution case. Mr. Nath, if you give some assurance that you are going to satisfy, only then I will interfere. Otherwise, no interference. Let the executing court proceed. Attach the properties of the deputy commissioners.
Well, right at this moment, it is difficult for me. Kindly give me a short time, my lord, so that I can come up, my lord. I have to discuss and I have to take up the matter with the authority, my lord. at least the date is fixed on 30th of June. For some time, kindly protect us.
Now, why this court should protect you? I am not finding any reasons.
In the interest of justice, ultimately the entire.
What is in the interest of justice?
Well,
To
if-
debar the decree holder from the fruits of his decree.
No, no,
Is
no.
it in the interest of justice?
I-
What you mean by the phrase interest of justice?
My respectful submission is that the district administration, otherwise it will be entire administration will be jeopardized. So
That you should have been aware about this fact that this may happen, but you took the things for granted for last 12 years. And on a drop of a hat, court will not issue stay of execution in an undeserving case. You satisfy me. You have failed to satisfy by filing. Yes, Mr. Nath.
My humble submission is.
And you are also equally responsible.
Lordship, here, yes, but I am not aware of the current state, Lordship. This has been filed today. What is the current position, Lordship, that I can find out, Lordship. Today I have just appeared, Lordship. As to why there has been a delay, Lordship, that I can, and as to when.
No, that order sheets reflects
Yes, Lordship,
why there has been delay.
Yes. Right.
No stay.
My respect.
Heard.
I respectfully submit, but the public interest which I am pressing before your lordship is that the administration otherwise will suffer huge difficulty.
You
That is-
pay
that is
the you pay the amount. You save the district administration from properties being attached.
Right now,
You still have 4 days.
But right now, I don't have the instruction. I have to talk to the DC. But I don't know the position. Without asking, without talking to them, I can't assure. That is my limitation. That is my limitation. Or at least if lordship for some time it gives us for some time is given to us just to have some discussion and all.
Discussion for what?
In what manner they can, if at all they can, I have to apprise that.
No, if you are unable to satisfy decree, the execution has to be as per law.
That's
Neither are you giving any assurance to this court that you will satisfy the decree. No, you are not here or there.
I have two submissions. Number one, to give assurance before the honorable court, I have to take the specific instruction from my client. That is number one. Kindly accommodate me for some moment so that I can talk to him. And secondly, my submission is that the respondent number 9, the director of health services, they are also before your lordship. He can also have the instruction that what is the position of the fund, because they are in the process. The record reveals that they're in the process of satisfying the decree. Although the district administration is a part in the decree, and at that point of time they have not.
This shifting of responsibility in between the judgment debtors. I am not at all impressed. Heard, Mr.
Protect till few days, at least so that I can come back with the instruction.
Heard, Mr. D. Nath Lanin, Senior Government Counsel, appearing for the petitioners. That is State of Assam and others. Also, Mr. What is your name?
Soliha, Lordship, for respondent number.
Soliha, appearing for respondent number 9.
Page 4.
This application under Article 227 of the Constitution of India has been filed by the present petitioners, who are the judgment debtor in title execution case number 3/2017 in connection with title suit number 434/2007, impugning the order dated 26/5/2026, whereby the executing court has issued warrant of attachment of the properties of the judgment debtor and fixed the date for submission of compliance report on 30/6/2026. Learned Senior Government Counsel Mr. D. Nath submits that though the prime judgment debtor in the instant case is the main judgment debtor in the instant case is the who is the respondent number?
Nine.
Respondent number 9. That is
In fact, page 42, page 42, they appear.
respondent number 9. That is respondent number 9 is Superintendent PHC.
They implemented them like that, but it is under control of the Joint Director of Health Services.
This respondent number 9. Who learned government senior government counsel submits that are under the control of Joint Director of Health Services, South Salmara. One line to production. Who are under the control of, however, the executing court has issued writ of attachment of the properties of the present petitioner number 2, that is Deputy Commissioner South Salmara. He submits that if the writ of attachment is executed, it would cause immense difficulty into day-to-day administration of the affairs of the district. He further submits that the records of the executing court shows that there have been several interdepartmental correspondence, and the Joint Director of Health Department is taking steps taking all steps for satisfying the decree and as such satisfying the decree. Stop. He therefore submits that the impugned order may be stayed for some time so that necessary instructions may be obtained by the present petitioner regarding the status of regarding the stage of progress of complying with the decree. On the other hand, Mr. What is your name?
A. Solia, Lordship.
Mr. A. You are standing counsel.
Yes, for the health department.
Mr. A. Solia, learned standing counsel, health department, submits that he needs some time for taking necessary instructions as regards the status of steps taken by the respondent number 5, judgment data number 5, with regard to compliance of the decree. On perusal of the records of this case, it appears that the title suit number 434/2017 was decreed in the year when it was decreed
21 to 2014, page 18, serial number 3.
Decreed on 21 to 2014, and thereafter the decree holder have instituted title execution case number 21/2000 title execution case in the same year, which was later on renumbered as title execution case number 3/2017. It also appears that from the record of the from the documents annexed with the instant revision petition, which pertains to the records of the title execution case number 3/17, that several opportunities were granted to the judgment debtor to satisfy the decree by the executing court. However, it appears that apart from referring to interdepartmental correspondence, no progress has been made regarding the satisfying of the decree by the judgment debtors. The present petitioners are also judgment debtors, and they are equally liable to satisfy decree along with the decree judgment debtor number 5, that is health department. Since Mr. D. Nathlan, Senior Government Counsel, has prayed for some time to take necessary instructions to intimate this court regarding this. No, since on a query posed by this court as to whether the learned senior government counsel is in a position to assure this court that the decree shall be satisfied within a specified period of time, the learned senior government counsel has prayed for some time to reply to the same after taking necessary instruction. And since the consequence of consequence cutting, this court is granting some time to the petitioners to intimate this court regarding the steps sometime to the petitioner or sometime to the learned counsel for the petitioner. At the same time, the learned counsel for respondent number 9 is also directed to intimate this court regarding steps taken by the health department to satisfy the decree. Stop. Issue notice to the remaining respondents. Since Learned Standing Council Health Department has already appeared for respondent number 9, no formal steps needs to be taken for issuance of notice on the said respondent. Let this matter be listed on 3rd of August. Till that day, the warrant of attachment issued by the executing court shall not be given any effect. So, list accordingly.
Next one is item 3. In this case, I want to point out that there was a KBIT was filed by respondents, but we telephoned them. Registry also tried to contact them, but they failed to. Their report from registry is next year. Last page of the
Respondent is state of Assam.
no, Lordship, private respondent is also there. So what happened in this case? We filed a commercial suit before the Learned Civil Judge No. Initially, suit was entertained, but Lordship on 18/5, Learned Trial Court says that since the notification on which we have relied on was set aside by the Honorable Gauhati High Court, so I have no jurisdiction. Then we prayed to that plaint and along with the injunction will be returned to us. But Lordship, without returning the plaint, Lordship, the Learned Trial Court has fixed the matter on 28/7 for further hearing on maintainability. Lordship, may come to page 269. This is a notification by which commercial court has been constituted by government of Assam.
269.
Annexure 9. Notification dated 13th of February 2019.
This has been nullified by
Yes,
a
sir. Yes, by this
division
one.
bench of this.
Yes, sir. Next page, page 270. This is judgment by which Lordship the note this notification has been said to be non-esteemed law.
Yes.
Lordship, we prayed before the Learned Trial. Lordship may come to page 267. On which date, Lordship, we come to know that Learned Trial Court has no jurisdiction to entertain the suit. So we prayed that plaint may be returned to us, but in spite of making such prayer, also the learned trial court has fixed the matter for.
You file any application under
Lordship,
order
Lordship,
seven?
Lordship, page 267 is a clear order, Lordship. The learned trial court has himself submitted that court has no jurisdiction, Lordship. And on 28/6, we made prayer on 18/6. We made prayer that since this court has no jurisdiction, so
You
return the
made
plaint.
prayer by filing any
No,
application?
Lordship, we didn't, but
Oral prayer.
orally we made prayer. We filed Hajira and we made necessary argument before the Honorable Court.
Which order you are impugning?
Lordship, page 267. Order dated 29/5/2026. Lordship, in this case, the learned trial court entered in our suit and initially an interim injunction was granted. But on 29/5, injunction was refused. And learned trial court says that the court has no jurisdiction. So Lordship, I have a twofold prayer made before the learned trial court that the order passed by Honorable Trial Court, when court has no jurisdiction, all order passed by learned trial court has become nullity. And since the court has no jurisdiction, so return our plaint and injunction petition for placing before the private court having jurisdiction. But without Lordship entertaining that prayer, the learned trial court fixed the matter on 27/7/2026 for further hearing on parties from maintainability.
Suit was your own suit.
Yes, suit.
You are saying it is not maintainable.
No, Lordship, since we filed our suit on the basis of Annexure 9, page 269. At that time, we were not aware, and the suit was entertained by the learned trial court also. On 29/5, the learned trial court said, I have no jurisdiction. Then we made prayer that since this court has no jurisdiction, return our plaint along with the injunction petition.
Now what do you want now?
Lordship, that is, we have.
Because there is a caveat.
No, Lordship, we are hanging in the middle, Lordship. Because neither we can file any appeal, and in the meantime, on 29/5, our injunction was also rejected by the learned trial. So Lordship, since the court has no jurisdiction, the order became nullity. Lordship, we cannot file any appeal against that order.
Now what do you want now?
Lord said that necessary direction will be issued to the learned trial court to return our plaint along with the injunction petition.
But the caveator is not before the court.
Lordship, we contacted them. Lordship, there is a report from the registry also. Lordship, report is also annexed here with Lord.
Last page.
Where?
Last page.
Last page of the
Notice. Last page of this file, Lord. There is an undertaking.
No, refuse to accept notice.
They said that they have not come to the court, so they are not in position to accept the notice. Probably, Lordship, if our
The trial court has fixed a date for hearing. Trial court has not refused your prayer.
correct, Lordship, but we cannot file our Lordship, my submission before Lordship, when court has no jurisdiction, any order passed by that court has become nullity, Lordship. And the problem before us is, Lordship, the matter is very urgent, since our prayer for injunction has been refused by the learned trial court. We cannot file appeal also, Lordship, unless it is returned to us. And we knows that when the court has no jurisdiction, Lordship, we cannot file an appeal also. That's why we are before this honorable court.
Which is the appropriate court?
Lordship, this matter is under trademark, so under
District judge.
district judge. Lordship, here interesting part is that on one side court has said I have no jurisdiction, and on the other hand, Lordship, court has rejected our injunction petition. We have also annexed the injunction order, Lordship.
No, we are fixing a short. When is the date?
27/7. Lordship, there is no difficulty in fixing, but our problem, we cannot approach any court, Lordship. In people effects on finance of
But notice has to go.
No, Lordship, correct.
We'll fix on the reopening day.
Lordship, in the meantime, further proceeding may be kindly missed.
Further proceeding is on 18th, 27, 27/7. We are fixing this on 13 of 7. Heard Mr. A.C.K.L. Learned Senior Counsel assisted by Mr. K. Jain, Learned Counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated. Which order?
29/5/2026.
29/5/2026 passed in commercial suit number 52/2026 by the Court of Learned Civil Judge, Senior Division number 1, Kamrup Metro, Gauhati. Stop. Learned Senior Counsel submits that by the said order, on the said date, it was brought to the notice of the court that the notification dated 13 February 2019 of the Government of Assam notifying the Courts of Civil Judge Senior Division as commercial courts in the state of Assam has been nullified as non-est in law by a judgment of Division Bench of this court in the case of Messrs. Brahmaputra Distillery and another versus Associated Alcohol and Beverages Company within bracket judgment dated 18/2/2025 in FAO number 73/2025. However, in spite of the fact that the Court of Learned Civil Judge Senior Division Kamrup Metro does not have jurisdiction to act as commercial court under the aforesaid notification. The oral prayer made by the present petitioner to return the plaint to the petitioners under Order 7 Rule 10 of the CPC was not acceded to by the trial court. Rather, it fixed the matter for hearing on the question of maintainability on 18/6/2026, and thereafter the said date was extended to 27/7/2026. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 13th of July 2026. List recording.
Your Lordship.
Yes.
Your Lordship, this present interlocutory application is for correction of a typographical error on our part, Your Lordship, at page number 8, the cost item. Page number 8.
Yes.
Your Lordship, here, as per respondent number 1, 2, and 3, wife of late Rajiv Ahmed, alias Rajibuddin, for the second respondent, daughter of late Rajiv Ahmed, and third, following late Rajiv Ahmed, it ought to be late Surajit Sinha, Your Lordship.
Suspika Sinha.
Sabha Sinha, wife of late Surajit Sinha, Your Lordship.
Any objection?
There was some clerical mistake. There's no objection.
Heard Mr. A. Iqbal, learned counsel for the applicant. This interlocutory application has been filed by the applicant slash claimant's respondent, praying for correction of a clerical error which has crept in the cause title of the order dated 27/10/2025, passed in IA within bracket civil number 3382/2025. Learned counsel for the applicant submits that in the cause title against the name of respondent number 3, it has been shown that Srimati Susmita Sinha is the daughter of late Rajiv Ahmed, whereas it ought to have been Susmita Sinha, daughter of late
Surajit Sinha.
Surajit Sinha.
Lordship, in respect of claimant number 1 and 2 as well. Shobha Sinha and Shaini Sinha.
I'm for that.
Okay. In not in respondent number 3, in respect of respondent number
1, 2, and 3.
1, 2, and 3, in place of Rajiv Ahmed alias Rajibuddin, the name of Surajit Sinha ought to have been there. The learned counsel for the appellant, Mr. S. Sharma, submits that also does not raise any objection to the said prayer, and he submits that same is an inadvertent clerical mistake. Stop. After considering the submissions made by learned counsel for the both sides, it appears that the error which has been pointed out by the learned counsel for the applicant is an inadvertent clerical error which has crept in the order dated 27/10/2025, passed in IA Civil number 3382/2025, and same is required to be rectified. Accordingly, this interlocutory application is allowed, and in the cause title of the aforesaid order against the name of respondent number 1, Srimati Shobha Sinha, where she has been shown as wife of late Rajibuddin Ahmed, Rajiv Ahmed alias Rajibuddin Ahmed, it shall be deemed to be the name of wife of late Surajit Sinha shall be read in. Similarly, against the name of respondent number 2, Srimati Shaini Sinha, daughter of late Rajiv, in place of Rajiv Ahmed, the name of daughter of Rajiv Ahmed, daughter of late Surajit Sinha shall be read. Similarly, in place of respondent number 3, that is Srimati Susmita Sinha, daughter of late Rajiv Ahmed, it shall be read as daughter of Surajit Sinha, late Surajit Sinha. With above observation, this interlocutory application is disposed.
In the meantime, we can file amended post title in main appeal, Your Lordship.
Yes, the You are not the appellant.
Is the insurance
They will file in the meanwhile, the appellant shall file the amended cause title in the connected MAC appeal number
476/25.
476/2025. 2026 list accordingly.
Production list I have 4.
Your Lordship. Lordship, in this matter, we have challenged the order passed by the learned Civil Judge Senior Division, Morigaon, Lordship. Order is at page 15B, starting from page 15B till page 17, Lordship.
Page number
15B. Relevant portion is at page 16, Lordship. And 17, Lordship.
Yes.
In this order, we have challenged the we have prayed for the injunction against the order passed by the respondent number against the possession notice issued by the respondent number 1, which is at page annexes 6, page 56, Lordship. We have prayed for the injunction of this notice, Lordship. Lordship, what happened, Lordship? In this matter, Lordship, respondent number 2 had married to petitioner number 3 in the year 2007, Lordship, under Special Marriage Act, Lordship. That certificate was 2007, under Special Marriage Act, which we have annexed as Annex 2, Lordship. After, in the year 2016, respondent number 2 had obtained a loan from Reliance Capital Finance Limited, Lordship, keeping respondent petitioner 1, 2, and 3 as co-borrower in that loan. And in return, they have mortgaged their property to the Reliance Finance Limited. In the year 2017, respondent number 2 had conducted another second marriage, in which petitioner number 3 had left her matrimonial home and stayed with her parent in her parental home. Immediately after she left her matrimonial home, respondent number 2 had stopped paying the EMIs of the loan, which petitioners are not aware of the fact. In the year 2018, when they have received notice from Reliance Finance Limited, then they have instituted a title suit, which is in the Court of Civil Judge Senior Division, Morigaon, which is numbered registered as 22, title suit number 2280.
Heard Mr. R.N. Das, learned counsel for the appellant. This appeal under Order 43 Rule 1R has been preferred by the appellants, impugning the order dated 15/6/2026 passed by the Court of Learned Civil Judge Senior Division, Morigaon. In Miss J case number 57/2026 in connection with title suit number 22/18, rejecting the prayer for grant of ex parte ad interim injunction against the opposite parties. Issue notice to the respondents. A. Petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of August.
Lordship, I have a small prayer, Lordship. Page 15, interim, Lordship. At least status quo may be met.
Returnable date. The impugn order dated 15/6/2026 as regards rejection of the prayer for grant of a ex parte ad interim injunction shall remain stayed, and the respondent shall maintain status quo in respect of the suit property
Page,
or the notice.
page 15, Lordship.
In respect of the notice dated
Page 6, 26, Lordship. That is.
notice dated May 6, 2026 till next returnable date, list accordingly.
Order, item 16.
Admission to Madhya Pare. Admission to Madhya. 14. Admission at the SNE after this month.
Wait, please, your lordship, TCR is not received yet, expect reminders.
The appearance of parties is complete.
Yes, yes.
What is your name?
Yes, Sharma, on behalf of Mr. B.K. Singh.
Ms. S. Sharma. Appearing for the appellant, also on Mr. What is your name?
R. Sharma on behalf of 800.
Allah Sharma. Appearing on behalf of Mr. Aidar. On perusal of the office note, it appears that the records of the trial court have not yet been received. Issue reminder for the trial court records registry to send take steps. Let this matter be listed 12th of August. Matthew.
Item 14, Prohibitions.
Actually, for the timing, so the timing.
Item 45 from supplementary list.
Wait, please.
Yes.
Wait, please, all. This is in petition under section 37(1)(b) against the order passed in under section 9 of Arbitration Act, my lord. The petition is in page number 31, my lord. Ms. 59, 2026.
Where is the impugn order?
The order is in page number 16, my lord. Relevant portion is page number 28, my lord.
What was done by the impugn order?
The order is, my lord, page number relevant portion in page number 25, 28, having regard to the nature of relief sought, the advanced stage of the arbitration is stated to be at the stage of final and pronouncement of the about the discretionary character of the jurisdiction under section 9 of this act. The court is of the considered opinion that the petitioner have not made out a case warranting grant of an ad interim ex parte in the injunction prayed for. Accordingly, this court is not inclined to grant an ad interim ex parte injunction prayed for at this stage. Our main issue is, my lord, under Schedule 7 rule item number 1, my lord, the past and present relationship with the party with arbitrator, my lord. That is our ground, my lord.
No, but the court has not rejected your prayer.
Rejected, but not
It has only issued notice.
issue notice, my lord, but inclined to
When-
grant an ad interim ex parte order, my lord.
When is the arbitration proceeding is fixed? 27th of.
7-6, my lord.
At what stage arbitration is pending?
The claimant side is going on, my lord. Because, my lord, we have approached severally before the arbitrator by filing application, my lord, but the arbitrator did not consider our application, my lord. And kindly see one of the main thing, my lord, that is section 12, my lord, that is in page number. Section 12, page number, my lord. Page number 60 is the first sitting, my lord. After coming, after remanded to the, we have already filed a review petition before the honorable court, my lord, and review order the honorable court, my lord. That is in page number 48, my lord. Kindly see page number 48, review petition.
We against what? Which one?
Against appointment of arbitrator, my lords. And 52 is the relevant portion, my lord. Direction of the honorable high court, my lord. Is number 52, my lord. Considering the issue involved and submission made before the court, as also judgment referred to this court in the view that review petition can be disposed of at this stage by directing the parties to appear before the arbitrator. The arbitrator will decide the issue by passing a fresh order on the objection raised by the review petitioner. The arbitrator, upon hearing the parties, will pass the appropriate order on the objection raised by the review petitioner, read with provision with the Act 1996 and the rules renamed thereunder before the proceeding any further in arbitration proceeding. With the above observation, review petition can dispose of and parties will appear before the arbitrator. And accordingly, we have appeared before the arbitrator, my lord, but without hearing us, my lord, the honorable arbitrator passed the order that is in page number 58, my lord. Kindly see.
What objection you have raised?
Objection is my lord, page number 108, my lord. My lord. She is the counsel against us, my lord. Arbitrator is the counsel, my lord. That is pending case, my lord, 108, my lord. My lord, is here party respondent number 4, my lord. Kindly see. Commander works engineer, CWE in Tezpur. Here the work is for the Tezpur, my lord. CWE Tezpur, my lord. And she is the counsel, my lord. Kindly see the name of the counsel is right in the petitioner's and advocate's name, my lord. And another case is 110, my lord. There are two cases, my lord.
Good, Miss Egan, Learned Central Government Council, appearing for the appellants. This appeal but appeal lies before the district judges court.
This is section again 37(1)(b), my lord. Against section 9, my lord. 37(1)(b), my lord. Kindly see.
In section 37 within bracket 1 within bracket small b of the Arbitration and Conciliation Act, impugning the order dated 8/6/2026 passed in Ms. J case number 59/2026 arising out of Ms. Arbitration case number 8/2026, whereby an application whereby prayer of the present petitioner for grant of ex parte ad interim injunction against the Where is the impugned order?
Case number 16, my lord.
60?
16.
But identity injunction was rejected. Learned counsel for the petition appellant has submitted that the arbitration proceeding is presently fixed before an arbitrator against whom the present petitioner has raised the issue of bias.
This my lord 14 to amended to withdraw, my lord. Because he has my lord, under Schedule 7(1), Item 1, my lord. He has the past relationship, my lord.
Count of past relationship
Yes.
with one of the parties. She submits that the appointed arbitrator has appeared as counsel for the adverse party against the present petitioner in a case. She further submits that the arbitration proceeding is pending for final hearing and is fixed when?
27(6).
On fixed tomorrow, that is 27/6/2026. Issue notice to the respondents. The petitioner shall take steps for issuance of notice against the respondents by speed post along with as well as by usual mode within 7 days from the date of this order, returnable on 6th of August. In the meanwhile, considering the submissions made by the learned counsel for the petitioner, further proceeding of arbitration proceeding pertaining to CA number CWE/AF/TEZ/11 of 2008/2009 pending before the learned arbitrator. Miss, what is the name? Name of the arbitrator? Miss M. Bora shall remain stayed till next returnable date. List according.
Top license.
Yes.
Wait, please, my lord. My lord, may kindly refer to your lordship's order dated 19/12/2025. The very first order passed by your lordship. At paragraphs 3 and 4.
Yes.
My lord had inquired as to the provisions of this is a petition under section 16(3) of the Indian Telegraph Act 1885, wherein my lord compensation was awarded by the learned district judge. My lord, your lordship had put up a query whether Article 227 or Section 115 shall
be applicable in this case at para 3 and 4.
Yes.
Now, my lord, recently, my lord, the Supreme Court in Kalpataru Power Transmission versus Vinod and others, this judgment was passed by the Supreme Court, my lord, where the Supreme Court is also, they have also observed that there's no provision where distinct procedure for appeal or revision can be has been enacted in the 1885 Act. At para 25, if I may read, my lord, at page 30 of the judgment. Page 30, para 29.
Yes.
The Supreme Court says, as is evident from the provisions of the 1885 Act, there is no amendment in sections 10 and 16 ever since the same was enacted. It may be noted that when the 1885 Act was enacted, there was limited development and there may have been a few cases requiring determination of compensation under the aforementioned Act. The value of the land was also in peanuts. However, with the rapid pace of development in the electrical and power sector, the volume of litigation has increased significantly, necessitating assessment of compensation under the 1885 Act. At para 30, besides there being no appellate remedy, we find there are other gaps as well in the statutory scheme. Now, coming to para 33 at page 34, my lord. Para 33, if I may read, my lord.
Yes.
Needless to add here that in the process of determination of compensation, evidence will have to be led by the parties. Unless statutory remedy of appeal is provided where all issues of law and facts can be re-examined, any other remedy may be illusionary. As is noticed in the facts of the present case, the remedies availed by different parties were different. In some of the cases, writ petitions were filed by the landowners under Article 226 of the Constitution of India, impugning the judgment and decree of the Civil Court. And in some of the cases, the contractor as well as the landowners filed petitions under Article 227 of the Constitution of India. Reappreciation of evidence in those proceedings may be an issue. A remedy may not be effective and can become illusionary. Not only this, but anomalies as have been referred to in the paragraph 30 with reference to various timelines as well, the matter needs to be examined. In the aforesaid background, we are of the opinion that these issues need to be examined by the Law Commission of India and the Ministry of Law and Justice, Government of India, so as to determine whether a statutory remedy of appeal should be provided against judgments, orders passed under Section 16.3 and 16.4 of the 1885 Act, the Petroleum Act, or any other similar statute. So, my lord, in this judgment, my lord, the Supreme Court has sent back the whole issue to the Law Ministry to examine and enact proper law.
But 1885 Act does not provide for an appellate remedy.
No, my lord.
Okay.
So we are filing under Section 27, some under 226. So the Supreme Court says that the Law Ministry and the Law Commission of India needs to examine this matter at length and pass appropriate orders or enact special laws in this regard. So, my lord, the 227 article 227 petition that we have filed such as until they take a decision.
Okay. Now, what is the stage in this case?
My lord, in our appeal here, my lord.
Who is for the other side?
The other side is not here, my lord.
We'll fix it after vacation.
My lord.
Heard Mr. R. Sharma, Learned Senior Counsel Assistant Minister.
He's on PC, my lord. He's from Shillong. He's on PC.
My lord, briefing counsel of the senior advocate, my lord.
What is your name?
T. Marngar, my lord.
T.
Marngar.
Marnar, Learned Counsel for the petitioners. None has appeared for the respondents. When the matter was called on, Learned Senior Counsel for the petitioner has submitted that on 19/12/19 2025, a query was posed by this court as to whether there is any appellate provision under Indian Telegraph Act 1885 against an order / judgment passed by the district judge under section 16 of the said act. Learned senior counsel, by referring to a judgment of the apex court in the case of Kalpataru Power Transmission Limited versus Vinod and others, within bracket civil appeal number 10882-10888 of 2025, has submitted that presently there is no appellate provision against the order of a district judge, and by the aforesaid judgment, the apex court has referred the matter to the government as well as to the Law Commission of India to take appropriate steps in this regard. He therefore submits that under such circumstances, an application under Article 227 of the Constitution of India is maintainable. List this matter date at the first week of August, 3rd August. Show the name of Miss M. Kalita, learned counsel for respondent number. Respondent number 1. 3rd August. The interim order shall continue till next date.
Item 17.
Also, in this case, Lordship, in the IA Lordship, we had prayed for staying at the PCI proceeding Lordship. My management had appeared for the claimant and they had filed objection to Lordship. But other day, Lordship, the engaged counsel was unable to present. Today also, he has stated that he is not in a position to appear, Lordship, due to some difficulties. But in the meantime, Lordship, some development had taken place, Lordship. The Bakijai officer had issued a notice to the company, Lordship, that Bakijai proceeding is not state, Lordship, only warrant of arrest is state, Lordship. So I apprehend, Lordship, the Bakijai officer may take steps to initiate, Lordship, to realize money by attaching property of the company, Lordship. So my humble prayer is that Bakijai proceeding may be state, Lordship. Otherwise, we are ready to here to submit our part, Lordship, but otherwise it is taking time.
Yes, you are appearing for?
Appearing on behalf of Mr. A. Sinkia.
Heard Mr. A.J. Sakya, the learned counsel for the applicant. Also heard Mr. What is your name? What is your name?
S. Talukdar.
S. Talukdar, learned counsel, appearing on behalf of Mr. A. Sakya. There is some difficulty.
Sir, he is suffering from a fracture. I have the medical document.
Okay. Who prays for an adjournment on the ground that conducting counsel for the respondent / claimant is indisposed. The prayer is allowed. On the other hand, Mr. A.J. Soikia, learned counsel for the applicant, has submitted that though an interim stay has been granted or was granted by this court against execution of the warrant of arrest issued by the Bakijai officer. However, in the meanwhile, since the Bakijai proceeding in Bakijai case number 89/2024 within bracket MECT pending before the Additional Deputy Commissioner Kamrup Metro within bracket Certificate Officer Bakijai branch has not been stayed. The applicant apprehends that the certificate officer may take adverse steps for realization of the awarded amount by taking recourse to coercive measures. He therefore prays for staying the further proceeding of the Bakija case number BJ 89/2024 within bracket MECT pending before the certificate officer Bakijai branch Kamrup Metropolitan District till further order. The prayer is allowed. Let this matter be listed again on 10th of August. Till then, the further proceeding of Bakijai proceeding shall remain stayed. The interim stay granted earlier in respect of the execution of the warrant of arrest shall also continue till next date. List accordingly.
Should we take up the MEC appeal also, Lordship?
MEC appeal.
MEC appeal, Lordship, we have taken steps. Copy is given to the claimant by hand, Lordship. But office note dated 24/6 says that 3 and 4 were expired, Lordship. That's one number 3 and 4.
What 3 and 4?
We will have to take a step for asserting their legal heirs particulars. And
Heard Mr. H.S. Vikal, learned counsel for the appellant, also heard Mr. S. Talukdar appearing for the claimant/respondent. On perusal of the office note dated 14/6/2026, it appears that the notice issued to respondent number 3 and 4 have returned with an endorsement that respondent number 3 and 4 have already expired. Stop. In view of the said office note, learned counsel for the appellant seeks some time to take appropriate steps with regard to the deceased respondents. The prayer is allowed. Let this matter be listed again on 10th of August.
in respect of respondent 2, we will take steps again, Lordship.
As regards respondent number 2, the insurance company shall take fresh steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of August.
Lordship, another prayer is dear Lordship. In the case, Lordship, one IS civil was there 2337/19. That was also Lordship closed earlier when case was dismissed 44. But by Honorable Court's order 10/3/26, Lordship, in MEC appeal 43/23, that was directed to be restored. In the last date also it was listed, but today it's not there.
No, what is this?
IS civil Lordship 2337/19, that is the stay petition we had filed against the impugned judgment, Lordship.
But this was closed.
This was closed, but Lordship may be pleased to go through the order dated 10/3/26, Lordship.
No, but the stay has been granted.
Lordship, that petition is yet to be disposed.
No, that petition has already been closed.
Lordship had passed order on 10/3/26 in the MEC appeal. Lordship may be pleased to go through, Lordship. It was directed to take that, to restore that, to list that case, Lordship, along MEC appeal. Order dated 10/3/26, Lordship, in MEC appeal 43/23. Paragraph 9. And 10 also. Last date it was listed, today it is not there.
But no, why restoration is necessary? You already got the stay.
Lordship, that is our pray in the pray what are staying Bakija proceedings. This IA was for staying the main
Main proceeding means
proceeding means lordship that judgment
execution.
yes,
Execution has already been stayed.
yes, lordship, but this was the petition that we had earlier filed.
That need not to be restored.
Direction here, lordship, dear.
Okay. The registry is directed to list the IA civil number 2337/2019 along with this MSC appeal on the next date fixed. This record.
Obliged.
Item 18.
Should you agree some personal difficulty my senior had to leave early? Worship may take this matter of court application.
Third, Miss, what is your name? S. S.K. Laskar, learned counsel for the petitioner. Also heard Mr. H.R. Ahmed, learned counsel for the respondent. Learned counsel for the petitioner has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioners. The prayer is not opposed to by the respondent side, hence same is allowed. Let this matter be stayed on 3rd of August. The interim order shall continue.
Item 19 and 20.
Finally, item number 19, I have the instruction to appear on behalf of the insurance company, but I'm yet to receive the wakalatnama for which I could not file. I'll be filing shortly.
Otherwise, Lordship will kindly peruse order dated 22/10/25. I have already given him the copy. His name is also reflected as respondent number 1. 22/10/25 in my appeal. MSC appeal number 627. 627. He has already appeared in my MSC appeal and I have already given him a copy. And moreover, he has already filed a cross appeal, Lordship, against the same order.
So there was some delay. Delay was condoned. And that appeal
No, direction was given.
In my case, there was no delay, Lordship. My case was admitted long back on 9/12/25.
That is correct. That is correct.
In his case, there was some delay.
Delay that was condoned. And that item number 20 appeal has come for the first time.
What is how these appeals are connected? It is cross appeal.
Yes. Same award.
I have challenged the here award.
It is a cross objection actually.
Yes.
Both actually filed at a different time.
Okay.
I filed in 2024 with some.
Have you furnished the memo of appeal too?
Yes, yes, yes.
But
Yes.
there is no indication. There was a direction. You have not received.
My lord, that is appeal money.
You furnish one more.
As per this order dated 22/10/25. 22/10/25, I had already served him a copy, Lordship. I had already furnished him a copy. I am only for hearing the entire matter, Lordship, at the earliest, Lordship. At the earliest.
You
If
furnish.
necessary, the order may be stayed and payment of the already deposited amount may be disbursed.
Mr. What is your name?
G.J. Sharma, Lordship.
G.J. Sharma, learned counsel for the appellant in MEC appeal number 627, as well as respondent / claimant in MEC number. What is the number? Item number 20.
627/24.
Item number 20.
22.
20, my lord, 328.
328
328 of 26.
/ 2026. which has been filed by the
Insurance.
insurance company impugning the same judgment and award which has been impugned in MAC appeal number 627/2024. Learned Counsel, Mr. A. Bhattacharya submits that he has not received the copy of memo of appeal in MSc appeal number 627/2024. Though Learned Counsel for the appellant submits that in pursuant to the order dated 22/10/2025, he has furnished the copy of memo of appeal. However, the appellant is again the Learned Counsel for the appellant is again requested to furnish a copy of memo of appeal to the Learned Counsel for the insurance company. Who are the other parties? Owner driver. You are appearing for?
Lordship, in item number 19, I am appearing for respondent number 3. In 20, I am appearing for respondent number 5 on behalf of R.
Third, Ms. D. Goswami, appearing on behalf of Mr. R. Goswami for the respondent, namely, what is the name of your insurance company? United India Corp. United India Insurance Company Limited. And Mr. What is your name? M. Mandal, appearing for? What is name? What is the name of respondent number?
Malikon Khanum.
Who is he? Owner. Malikon Khanum. That is the owner of the truck bearing registration number AS 173073. Who is appearing for other owner? There is one more owner of the truck.
That is the bus. Asma Begum.
Whether notice has to go to that.
Yes, yes.
Done, Lordship. 22/5/26, Lordship will see for R4 it is already served, Lordship. Order dated 22/5/26.
No, that is in.
In MAC appeal number 627, common order hoga, I'm sure. In MAC appeal number 627/2024, it appears that the notice issued to respondent number 4 has been duly served. However, the appellant in MAC appeal number 328/2026 is directed to take fresh steps for issuance of notice on respondent number 4 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August. List accordingly.
Lordship has admitted my appeal.
Yes.
There is another I for statement.
Both the appeals are admitted. Yes. You pay 50%.
That amount is already deposited by him. That is reflected in the office order, Lordship.
Can I deposit for?
Okay. Who has deposited?
This is for the first time it has come. 21451 of 26.
Let him deposit 50%.
Then
Who was directed to pay?
they.
The bus insurance company of the bus was not directed.
No.
The truck was.
Truck was directed.
Okay.
He's for the truck.
Heard Mr. A. Bhattacharya. Learned in IA number 2145/2026. Learned counsel for the applicant. This interlocutory application has been filed by the applicant in connection with MAC appeal number 328/2026 under 41 Rule 5 of the Code of Civil Procedure 1908, praying for stay of execution of the impugned judgment and award dated 27/6/2024 passed by the Motor Accident Claims Tribunal Dhubri in MEC case number 23/2021 within bracket D, whereby the present applicant was directed to pay a compensation amount of rupees. How much?
12 lakh to pass.
13,35,000.
Amount of rupees 13,35,000 along with an interest at the rate of 7% per annum to the claimant respondent. The Senate counsel for the claimant respondent does not opposes the prayer, subject to the condition that the insurance company is ready to deposit 50% of the awarded amount as a condition for the grant of stay. Mr. A. Bhattacharya also agrees, Senate counsel for the applicant also agrees to the same. In view of the submissions made by learned counsel for both sides, this interlocutory application is allowed. The execution of the impugned judgment and award dated 27/6/2024 passed in MEC case number 23/2021 within bracket D shall remain stayed during the pendency of the MEC appeal number 328/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. In the event such an amount is deposited by the applicant before the registry, same shall be disbursed to the claimants/respondents by the registry after proper verification. With above observation, this interlocutory application is disposed of.
Much obliged.
Obliged.
I did 21.
My lord. This I is pending for condonation of delay, Lordship, in presenting MSc appeal. Here, Lordship, respondent number 228 has appeared. Regarding respondent number 1, Lordship, we have taken a fresh step through speed post, Lordship. But as per office note 23/6/26, no etiquette or answer notice has been received back, Lordship.
When have you taken steps?
In the second week of
We'll
May,
direct the
Lordship, I think
registry
12/5.
to place the
But
postal
notice has been passed.
Heard Mr. P.J. Burman, learned counsel for the applicant. Also heard Mr. R.A. Majumdar, appearing for respondent number 228. On perusal of the office note dated 23/6/2026, it appears that the service report in respect of notice issued to respondent number 1 is awaited. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 1 by speed post before this court on the next date fixed. Place this matter immediately after reopening.
Lordship, I place one thing here. Here, Lordship, this respondent number 1 is not required, I think, because this award has been passed in favor of respondent number 3. Respondent number 1 has not contested this appeal yet.
One is,
The award has been passed specially to the mother.
who is one?
One, I think, was the wife. I think there was some dispute, but
We
in
will
the
wait.
award lordship, nothing has been explained.
Putul Kiman decide. We'll decide this on next.
Lordship.
Lordship,
Hmm.
kindly on 20th, Lordship, any date after 20.
20 July. 20 July. Let this matter be listed again on 20 July.
Lordship.
Item 22.
Yes.
Product on this item number 3, Lordship. I was not aware, Lordship, the item number 3, Lordship, I am appearing for the state, Lordship. Already notice was issued, Lordship, this case.
Item number production list, item number 3.
CRP.
Show the presence of Miss D.D.
Yes.
Burman.
So, but I am not aware that the production list, the matter was listed in the.
The order has been passed.
Yes, these are listed.
Okay. Your presence will show.
Correct.
Miss D.D. Burman, London Additional Senior Government Counsel, appears for respondent number 1.
Obliged.
22.
So in this case, there is a delay of 58 days. The claimant has appeared, Your Lordship. Respondent number 2 is the owner and driver. Notice may be waived, Lordship.
You are opposing.
I am for the respondent number 1, my claimant.
Are you opposing?
No, I have no objection then.
Heard Mr. R. Sharma. Heard Mr. S. Sharma, Learned Counsel for the applicant. Also heard Mr. I. A. Talukdar, appearing for respondent number 1. Learned Counsel for the applicant submits that the respondent number 2 is the owner and driver of the offending vehicle. And this appeal, in this appeal, what you are impugning on only quantum?
Mainly on quantum, and secondly, the FIR was lodged after 2 months from the date of the accident. There are some discrepancy in this case, Your Lordship.
You know, if you are challenging the liability, then owner has to be notified.
Alright, Your Lordship.
On perusal of the office note dated 7/5/2026, it appears that the service report in respect of notices issued to respondent number 2 is awaited. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post before this court on the next date fixed, July.
20 July.
Is this matter on 20 July?
Good.
Item 23.
Lords, I appear on behalf of Mr. Arbora. As per the last order, we were to finish our service of the summons on the other side. The service is completed. The Milord may fix this matter for hearing any day after the vacations.
Who is on the other side?
It's the okay.
But service report, office note says that service report is awaited.
No, it's as per my instruction, it was completed.
On what basis?
Once me give me another date, I'll instruct the senior that will finish the summary.
Heard Mr. What is your name?
S. Sharma.
Heard Mr. S. Sharma, Learned Counsel, appearing for
On behalf of
of Mr. R. Bora,
Arbora.
Learning Standing Counsel, APDCL, appearing for the appellant on perusal of the office note dated 23/6/2026, it appears that service report in respect of notices issued to respondents is awaited. When have you taken steps? There is no indication that you have taken steps or not.
As per my instruction, the steps were taken. Well, just give me any short date. I will come back with a solid answer with the.
The office note does not reflect anything about the appellants taking necessary steps for issuance of notice upon the respondents. The appellants are directed to take fresh steps for issuance of notice upon respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of August.
10th of August. Obliged.
Item 24.
My lord, in this matter, there is an IA by the respondents. We would like to file an objection on
IA for
a deposit of 50% of the entire award amount. I am for the appellant owner.
none has appeared for the IA in IA.
Yes, my lord. Myself for item number 24, my lord.
Mr. B.R. Das appears through video conferencing for the applicant. This application, you have filed any stay application?
My lord, we are going to file it together with the IA.
My lord, already we have filed an execution petition, my lord.
Okay, there is no stay, go for execution.
Yes.
I will take it up later on. No orders in I. You may file a written objection in I. In appeal, what is your name?
I'm N. Gogoi, appearing on behalf of M. Sarana.
Mr. N. Gogoi, Learned Counsel, appearing on behalf of Mr.
M. Sarania. His name is
M.
not
Sir.
reflected in the.
M. Sarania, Learned Counsel for the appellant. Also, Mr. B.R. Das, appearing for respondent number 1. The office note dated 23/6/2026 shows that the postal track consignment report of notices issued to respondent number 4 and 5 shows that the said notices were duly delivered to the addressees. Stop. Accordingly, notices sent to respondent number 4 and 5 are held to be duly served. What happened to other respondents?
One is representing 2 and 3.
Okay. The service of notice as respondent number 1 is representing respondent number 2 and 3 who are minors.
Yes, my lord.
One is minor, another one is the mother of the
2 and 3. Hence, the service of notice on all the respondents are complete. The records of MSc case, I say. Let the records of, let a reminder be issued calling for the records of MSc case number 791/2010 from the concerned tribunal registry to take steps.
My lord, 2020.
Let the matter be listed. 10th
7
of
August, can it be fixed, my lord?
7th of August.
highly advised.
Absolutely, my lord. Here, my lord may peruse the office note. 23/6/26, lordship. Here, lordship, respondent number 1, 2, and 3, that are served. I think my learned friend is ready. And respondent number 4, lordship, is expired, lordship. There is a report. And regarding respondent number 3, lordship, it is returned, lordship. But lordship, respondent number 4, regarding respondent number 4, lordship, in the trial, so respondent number 4 was ex parte, lordship, and respondent number 5 was struck out. It's available in para number 12 of the judgment. Page number 12 of it, para number 4.
Heard Mr. P.J. Burman, learned counsel for the appellant. Also heard Mr. S. Ahmed, appearing for respondent number
1, 2, and 3.
1, 2, and 3. Learned counsel for the petition appeal submits that though the office note shows office note dated 23/6/2026 shows that the respondent number 4 has expired. However, the said respondent have not participated in the inquiry before the Motor Accident Claims Tribunal, and the inquiry proceeded ex parte against respondent number 4 as well as respondent number 5. Hence, he prays for waiving the notice, striking out of the names of said respondent from the memo of appeal. Prayer is allowed. The names of respondent number 4 and 5 may be struck out. The records of concerned
Teacher has received, lordship.
MSc case has been received. Hence, this case is ready for hearing. List this matter for hearing on.
They may be directed to deposit the 50% of the
There is any stay
Lordship,
application?
I haven't filed any stay.
No stay
Also,
application.
any date fixed, I can conclude my hearing in one day, lordship. The simple issue is here.
24th September.
Any date, lordship, maybe fixed in short date, lordship, I can.
24th September, final hearing.
Final hearing. Already TCR is here.
Item 26.
All right, sir.
Lordship, as per office note dated 22/6, Lordship, respondent number 1 and 2 are served, and PCR has also come, Lordship.
Service is complete.
Yes.
Heard Mr. A.J. Sakya, learned counsel for the appellant. On perusal of the office note dated 12/6/2026, it appears that notices issued to respondent number 1 and 2 have been duly served. It also appears that records of the MSc case number 1093/2016 have also been received. Hence, this appeal is ready for hearing. Let this matter listed for hearing on 24th September.
Item 27.
None has appeared for the applicant on call. List this matter after vacation on the date to be fixed by registry.
Item 28.
Lordship, as per office note dated 23/6, Lordship, 1 and 2 are served, but 3, respondent number 2, we have advertently not taken state, Lordship. Delay of 29 days, so we will take state again, Lordship.
Mr. A.J. Sakya, learned counsel for the applicant, who prays for some more time for taking steps for issuance of notice upon respondent number 2 by speed post. The prayer is allowed. The applicant shall do so within 7 days from the date of this order, returnable on 10th of August.
Lordship, both ways, Lordship.
speed post as well as by user mode, returnable on 10th of August. List accordingly.
Made PCC Lordship. Lordship, as per office note dated 24/6/26, unserved notice for R1 postal remark not found returned back. R2 postal journal still it is in transfer. But the usual process report has not yet come, Lordship, because we had taken steps by both ways. So registry may place the not found, maybe at that point of time the person was not at home. So usual process report may be called by registry.
R.D. Majumdar, learned counsel for the applicant. Though the office note dated 24/6/2026 shows that notice issued to respondent number 2 has returned.
No, one.
One has returned with postal remark within inverted comma not found, return to sender, inverted comma close. However, learned counsel for the applicant submits that the applicant has also taken steps for issuance of notice by usual mode and report in regard of in service report with regard to the same is awaited. Stop. Let the service report may be further awaited. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 once again before this court on the next date fixed. Let this matter be listed 22nd July.
Hello, pleasure.
Item 30.
Lordship, according to court order dated 18/5/26, we were directed to file written objection. We could not file it, Lordship, due to some personal difficulties. So we'll pray for some time to file our.
Lordship, the matter is ready for hearing. The service is complete upon the respondents. Lordship may fix it.
What is this IA?
It is for the state.
Okay, we
On
can
two
announce
occasions-
if 50% is deposited, but
On 2 occasions, they sought time, Your Lordship, for filing an objection against the against the stay we were ready to deposit an amount of rupees 6,96,879. The amount awarded under the head of conventional heads and
conventional head, Lordship, the
Future
total amount was around something 2,15,000 something. And the
2,14,500.
judgment is around,
How much is the awarded amount?
audit amount is 39,12,487.
You want 50%, and they are saying 6 lakhs.
6,96,879. The amount awarded under the head of future prospect. as
Let
well
them
as-
file objection.
Lordship, the matter is ready for
We'll
hearing.
file
I'm not
written
pressing the IA.
You are not pressing the
No.
We'll file an objection immediately after objection.
main appeal sum.
Lordship, on 2 occasions they sought time.
Okay, no, we'll go ahead with appeal. In appeal, service is complete.
Yes, Your Lordship. Lordship, may peruse office note dated
In appeal,
23/6/2026.
heard Mr.
Agarwal.
R. Sharma,
S. Sharma.
S. Sharma, learned counsel for the appellant. Also heard Mr. A. Agarwala, learned counsel for the claimant respondent. Office note dated 23/6/2026 shows that the notices issued to respondent number 4 and 5.
Lordship, it has
And-
been mistakenly written as 4 and 5. 1 to 4 are already represented by the caveators here. And respondent number, Lordship may peruse flag M.
Oh, it is 5 and 6.
5 and 6, Your Lordship.
5 and 6 are duly delivered. Hence, service of notice in this case is complete.
LCR was also.
The records of the concerned motor accident claims case have been received. Hence, this appeal is ready for hearing. Place this matter 29 September. In the connected IA, the claimant may file written objection. list the connected IA also in the same date. We'll try to hear the main appeal. If hearing is not taken place, does not take place, then you can press for IA.
Grateful.
Obliged.
Item 31.
On the next date fix.
May it please your lordship, as per office note 24/6/26, the service is complete. Postal journal for R1 served on 3/6/26 and R2 and 3 2/6/26.
Sadi Majumdar, counsel for the applicant. The office note dated
24/6/26.
24/6/2026 shows that the notice is issued to both the respondents. But there are 3 respondents.
Yes, lordship. For one, it was served on 3/6/26, and for 2 and 3 2/6/26.
All the respondents have been duly served. How much delay is there?
22 days delay.
This interlocutory application has been filed by the insurance company / applicant under Section 5 of the Limitation Act 1963, praying for condonation of delay of 22 days in filing the connected MAC appeal. I have considered the grounds stated in the memo of appeal in the instant interlocutory application for the delay caused in preferring the connected appeal. So, the grounds stated may be regarded as sufficient grounds which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, the said delay is condoned and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission on a date to be fixed by it after vacations. This interlocutory application is disposed of.
Highly allowed.
Item 32.
32 lordship, actually like 29 only. The 32 appear creation. Notices for lordship office note dated. You are appearing for anyone in 32?
I'm appearing for respondent number 4.
4 is served. For other respondent, the postal remark has come as insufficient address. But again, lordship, the usual process notices report has not yet come. So registry can call for the usual process report.
But Ms. R.D. Majumdar, learned counsel for the applicant. Also, Mr.
N.H. Laskar.
N.H. Laskar, learned counsel who is appearing for respondent number 4. As regards other respondents, though the office note dated 24/6/2026 shows that the notices have returned with postal remark insufficient address. However, learned counsel for the applicant submits that the applicant has also taken steps for issuance of notice by usual mode. Hence, she prays to await service report for some time. The prayer is allowed. Wait for service report as regards notices sent to the respondent number 1, 2, and 3 by usual mode. Let this matter be listed. 27 July.
Item 33 and 34.
Yes. My lord, item number 33, it's a delay condone petition, my lord, in respect of filing the review petition, my lord.
33 IA 1934. Heard Mr. B.R. Das, learned counsel for the applicant. This interlocutory application has been filed by the applicant for condoning delay of 56 days in preferring the connected review application. Issue notice to the respondents. The applicants shall take steps for issuance of notice to the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th August.
Item 45.
34.
Earlier.
So this IA for the conditional delay of 95 days, Your Lordship, for some general reasons, Your Lordship. Firstly, we have filed a civil revision petition for wrongly, Your Lordship, and later a liberty was given to us to file a RSC. And later, and that period of time, Your Lordship, my family was going through some.
Mr. S. Ahmed.
My prayer is that, Your Lordship, if the condonation can be delayed without issuing of notice. No.
Notice has to go.
There is no,
Condonation without notice cannot be.
the discretionary power, Your Lordship.
No,
Your
no.
Lordship, because there is the
A right has accrued in the other party by lapse of limitation period.
If Your Lordship may please to fix the matter on immediately after vacation, because on 22nd, the report has been fixed for execution of the report.
Mr. S. Ahmed, learned counsel for the applicant. This application, interlocutory application, has been preferred by the applicants under Section 5 of the Limitation Act, praying for condoning the delay of 95 days in preferring the connected appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on.
No, Lordship, on 22nd, the execution report has been fixed. Can it be fixed before that, Your Lordship? Because if same is condo.
2nd of
July.
20 July.
Otherwise, Lordship, the RSA could not be hard, Lordship. Only on 15 or 16, Your Lordship.
16 July.
16 July. Much of that.
Item 49 from supplementary list.
My lord, please. My lord, is an application for withdrawal of 50% which has been deposited by the insurance company, my lord. My lord, the order relevant, my lord, will find in page number, my lord.
Who is for the insurance? Mr. S. Sharma. You have anything to say?
Subject to furnishing a bond, Your Lordship.
And Mr. A.B. Day, learned counsel for the applicant. Also, Mr. S. Sharma, learned counsel for the insurance company. This interlocutory application has been filed by the applicant / claimant, praying for a direction to allow the petitioners, applicants / claimants for withdrawing the, what is your name? Also, Ms. Ardas, appearing for respondent number 5, withdrawing the 50% of the awarded amount which has been deposited by the insurance company before the registry of this court in pursuant to the order dated 13/8/2024, passed in which case?
IS civil number 3563.
IS civil number 3563 /2020.
My lord, one correction, my lord. The date will be 22/11/2024, my lord.
22 in pursuant to order dated 22/11/2024. 22/11/2024.
Passed in IS civil number 3563/2024.
Stop. The learned counsel for the insurance company submits that the insurance company does not have any objection, subject to the condition that the petitioners, the applicant may be required to furnish an indemnity bond for
That is otherwise as per the registry SOP, my lord.
indemnity bond. Stop. The prayer is allowed. In view of the submissions made by learned counsel for both sides, the prayer made by the applicant in this interlocutory application is allowed. The registry is directed to disburse the 50% of the awarded amount deposited by the insurance company before it to the present applicant slash claimant on after proper verification, on furnishing of indemnity bond to the amount equivalent to the amount deposited by the insurance company before it. This interlocutory application is accordingly disposed.
In the appeal, my lord, will pass an order, my lord, with the.
In the appeal, the service is complete, your lordship. The respondent number 2, 1, 2 are represented and 5 is also represented. Respondent number 3 were duly served and respondent number 5 refused to accept the notice.
4, my lord, maybe.
4. Respondent number 4.
Office note, my lord, will peruse for a moment.
25/6.
Heard Mr. S. Sharma, learned counsel for the appellant. Also heard Mr. A.B. Day, learned counsel for respondent number
It's 1 and 2, my lord.
1 and 2, as well as Ms. R. Das, appearing for respondent number 5. On perusal of the office note dated 25/6/2026, it appears that respondent number 4 has refused to accept the notices, and hence the notice was hung on the conspicuous place of the addressee, that conspicuous place within bracket in front of the fence of the house of the addressee. Accordingly, the notice issued to respondent number 4 is deemed to be duly served. Notice, service of notice to all the parties is complete. The records of the motor accident claims tribunal have also been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing 1st of October.
Leave your pledge, my lord.
এটা কি হলো? Withdrawn.
Item number 50. 58.
Item number 50 and 50. Lord Mr. What is your name?
As Gautam, your lordship.
S. Gautam, learned counsel for the applicant slash appellant. Why are you withdrawing?
There is a compromise decree that has been, parties have settled, your lordship.
Who submits that? The matter has been amicably settled between the parties, and hence he has been instructed by the appellant to withdraw the instant appeal. The prayer is allowed. This appeal is accordingly dismissed on withdrawal. The connected interlocutory application is also closed accordingly. So withdraw. Finish. Hearing next time.
Maybe in September.
We are not giving date. We are showing it leftover.
Okay.
Registry will give date.
Proceed.
Happy holidays, Lordship.
Same to all of you.